think he wanted to appeal.
All rise. Circuit Court's now in session. Honorable Thomas R. Evans presiding.
Good morning. You may be seated. Calling the case of People versus Austin Charles Auxier, file 21-6595-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
Yeah, please, the court. Scott Moore for the defense.
And sir, are you Austin Charles Auxier?
Yes, I am, Your Honor.
Am I pronouncing your name correctly, sir?
It's not sure.
Thank you, Mr. Auxier. Mr. Auxier, previously, back on June 7 of 2021, you appeared in court. At that time, you pled guilty to the 10-year felony crime, commonly known as possession of methamphetamine. You appear here today to be sentenced. The maximum penalty the court could impose would be 10 years in prison. The minimum sentence would be discretionary with the court, and the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least so far, the departments estimate or calculate your applicable sentencing guideline range to be 0 to 17 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, Mr. Auxier?
Yes, I do, Your Honor.
Mr. Moore, have you gone over these two reports with your client?
Yes, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
We had a discussion with Agent Brubaker from the Department of Corrections regarding credit for time served. Based on review of the Register of Action and other court files, we have agreed that Mr. Auxier should receive credit for time served dating back to March 25th, 2021. That would be an additional 144 days for a total of 150 days jail time. Aside from that, we have no factual challenges.
So on page 1 of the CFJ 145, towards the top of the page under the heading jail credit days, you are asking that that be changed to 150. Is that correct, Mr. Moore?
Yes, Your Honor.
Do you have any objection to that, Mr. Webb?
No, Your Honor.
Very well, the court will make that change and will direct the department to do so as well. Is there anything else in either report of a factual nature you want to add to explain or contradict, Mr. Moore? Mr. Moore, do you have any challenges to the scoring of the prior variables or the offense variables or the calculation as to the applicable sentencing guideline range as being 0 to 17 months?
No, Your Honor.
Mr. Webb, I pose the same series of questions to you.
Thank you, Your Honor. I've reviewed the report. I have no additions or corrections to make to it, and I believe the guidelines are correctly scored.
Mr. Auxier, is there anything, sir, you want to say on your own behalf before the court passes sentence?
Just like for you to take into consideration that I'm now serving 3 years in MDOC. Two kids out there, I just want to get back to them, just pass me to get on the right track in life.
Thank you, sir. And on behalf of your client, Mr. Moore?
Thank you, Your Honor. We ask the court to follow the recommendation as regards following the plea agreement. We do not see that there is much to be gained by placing my client on probation while he is in custody with the Department of Corrections, or even for a short period of time after release while he's on parole. I am front loading this because I believe I understand. I think I know where we're headed with this. Mr. Auxier, is it true that you and I spoke in the jury room about the possibility that the court might exceed the sentence agreement? Did we talk about that? You need to speak up real loud.
Yes, we did.
All right. And I told you that in all likelihood, given your current circumstance, there is a very good chance that the court will impose further jail or prison time. Do you understand that?
Yeah.
We are asking the court to make any sentence imposed today to run concurrently with any other sentence that you have had imposed up to this point. Do you understand that?
Yeah.
The judge may or may not do that, but I believe he will. Do you understand that?
Yes, I do.
This agreement as to concurrent sentencing would only apply to any sentences for which you have already been ordered to serve time. Do you understand that?
Yes, I do.
You've told me that you have a hearing in Midland County on September 23rd, probably to enter a plea. Is that correct?
Yes, it is.
And then sentencing would come after that. Do you understand that?
Yeah.
That judge would not be bound by any order from this court or any other court up to that point regarding concurrent sentencing. Finally, you will be given the opportunity to withdraw your plea if the court exceeds the first kilogram cap. In the interest of time, I'm going to suggest to you that if any sentence that's imposed will result in the same earliest out date that you have for your current sentence, it would be against my advice to withdraw the plea. Do you understand that?
Yes, I do.
Much obliged, Your Honor.
Thank you, sir. And Mr. Ucksher, is there anything you want to say on your own behalf before the court passes sentence?
No, Your Honor.
And on behalf of your client, Mr. Moore?
I would ask the court to adopt the comments I've already made. Thank you.
Thank you, sir. And on behalf of the people, Mr. Webb?
Thank you, Your Honor. After discussions with Agent Brubaker and Mr. Moore, the people would also ask that to fashion a sentence that whatever time you would impose would run concurrent and not longer than his current sentence.
Thank you, sir. Very well, Mr. Ucksher, in order to punish you for what you've done, but to give you and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself. It's the sentence of the court. You must pay $68 in state costs and a crime victims assessment of $130, court costs of $500, and a fine of $500. The court-appointed attorney fees of, do you have an estimate, Mr. Moore?
$500.
Of $500. In addition, you must serve 1 year in the Clare County Jail, but you will receive credit for 150 days already served, and this sentence will run concurrently to any sentences you currently are serving in the Michigan Department of Corrections or any sentences that have already been imposed, that will run at the same time as those. Now, Mr. Ucksher, I have exceeded the sentence cap because there was a Briggs Killebrew sentence cap that I would not give you any initial incarceration. You understand that, sir?
Yes, I do.
Now, as a consequence, you do have the right to withdraw your plea and to go to trial or to seek some other resolution. You understand those things?
Yes, I do.
Knowing all of these things, do you wish to make a decision about whether you want to withdraw your plea, or do you want the chance to talk to Mr. Moore some more about this, or have you discussed it thoroughly with him already?
We discussed it earlier.
Do you know what you would like to do, Mr. Ucksher?
And now I withdraw my plea.
All right, thank you, sir. Then, Mr. Ucksher, it's my duty to inform you that you are entitled to appellate review of your conviction and sentence. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal, but a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. The record should reflect that the defendant has received his copy of the advice of appellate rights form. He remains in possession of his copy, and he has signed the receipt form acknowledging those facts, and the signed receipt form has been turned over to the court clerk. Any bond is canceled, and any bond that was posted in the defendant's own name will be applied towards court-ordered monies, and you are remanded to the custody of the sheriff, back to the custody of the Michigan Department of Corrections for the carrying out of any sentence in this case. Because any jail sentence, the jail sentence is concurrent to prison sentences. Thank you for being here, sir. Good luck to you, gentlemen. I'm sorry I kept you waiting.
Thank you.
Thank you, sir. Calling the cases, People versus Dominic Ryan Tyler, file numbers 21-6652-FC and 21-6655-FC, -FH. Would counsel identify for the record, please?
Morning, I'm Mark Webb on behalf of the people in file 21-6652.
Scott Moore for the defense.
Today is the date and time scheduled for a hearing in each one of these two files on the people's motion to revoke bond. Are we proceeding by way of a hearing on that motion or in some other fashion? Mr. Moore?
Thank you, Your Honor. I regret to inform the court that I received a call at 8:49 this morning from a person purporting to be Mr. Tyler's sister. I have no reason to doubt that, but I have no independent confirmation of that either. She advised that Mr. Tyler has tested positive for COVID and has been quarantined. I asked her to transmit some confirmation of that in writing. I have not received that as of this time. Thank you.
Thank you, sir.
I would say, Your Honor, that I did speak with Mr. Tyler last week. He was starting to sound a little rough, but he was aware of today's hearing and indicated he would be here. It sounded to me like he had every intention to be. Thank you.
Thank you, sir. Very well, the record should reflect this case was scheduled to be heard at 8:59 a.m. It's now 9:59 a.m. an hour later. Mr. Tyler has failed to appear, although there might be a legitimate reason for that failure. The court will order Mr. Taylor to appear in court in person on the defendant must appear in court in person at 9 a.m. on Tuesday, September 7, 2021 to show cause why his bond should not be revoked and why he should not be held in criminal contempt of court for allegedly failing to appear here today. The bond status will be continued until that time. It's now 9:50 a.m. by the court's clock. Mr. Tyler still has failed to appear.
Thank you.
Thank you, Mr. Moore. calling the case of People versus John Thomas Starkweather, file 18-6042-FC. Would counsel identify for the record, please?
Good morning, Your Honor. May it please the court, Scott Moore for the defendant probationer. Mr. Starkweather is present in the courtroom. Given the nature of the relief I'm going to request right now, I'm going to ask that he be allowed to remain seated in the gallery.
Okay. And sir, are you John Thomas Starkweather?
Yes, Your Honor.
Thank you, sir. Has the defendant tendered a plea of guilty to the probation violation charges?
Yes, Your Honor. It's my understanding we are here for sentencing. I had a discussion with Agent Coder before we went on the record today. Mr. Coder was fully seized of my client's increasing fragility, medical issues that have required extensive treatment and surgery. It was at Mr. Coder's suggestion that I am now requesting the court to adjourn sentencing, perhaps a month. We are trying to find a middle ground between the recommendation made by the department and the ends of justice, as well as looking after my client's physical health. So for these reasons, and with the concurrence of Agent Coder, I am asking the court to adjourn this another month.
Any objection to that procedure, Ms. Ambrositis or Mr. Webb?
I have no objection.
And is this the request of the department, Agent Brubaker?
It is, Your Honor. Thank you.
Thank you, ma'am. Very well. We'll adjourn the sentencing then until Monday, October 4, 2021 at 9 a.m. The bond status will be continued. The case is adjourned to the date and time indicated. However, you will have to be back here in court in person on that day, Mr. Starkweather, Monday, October 4, 2021 at 9 a.m. Do you have any other additional instructions you wanted to give to Mr. Starkweather, Agent Brubaker?
Thank you, Your Honor. Yes, Mr. Starkweather needs to contact his probation agent while in court.
Very well. Do you understand that, sir? You have to contact your probation agent as soon as you leave here. You understand that, sir? Thank you. I also want to remind you, Mr. Starkweather, you still are on probation even while you're waiting to be sentenced. And that means that you have to obey all of the terms and conditions of your probation order, even while you're to be sentenced, okay? Good luck to you, sir. We'll see you back here on October 4th.
But I don't have a jail copy yet. He's watched. Do you want to move on? Sure.
Calling the case of People versus Lauren Dean Robinson, file 20-6309-FH. Would counsel identify for the record, please?
Morning, Your Honor. Mark Webb on behalf of the people.
Scott Moore for the defense. Your Honor, if we could pass this matter for a few moments. I have not seen Mr. Robinson. I don't believe he's checked yet.
Thank you, sir. The record should reflect this matter. The schedule will be heard at 9 a.m. It's now 9:55 a.m. by the court's clock, and Mr. Robinson has not signed in. Passing on that matter and calling the case of People versus Eric Paul Schuff, file 21-6629-FH. Would counsel identify for the record, please?
Sean Brzezowski on behalf of the people.
And please, the court, Scott Moore defense.
Mr. Schuff, would you please raise your right hand to be sworn, sir?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Could you tell us your name, sir?
Eric Paul Schuff.
Mr. Schuff, you appear here today for a status conference in this case. And did your client want to proceed by way of a plea?
Yes, Your Honor.
And would that be a plea to count one?
No, Your Honor, I'm sorry. Even though we talked about this at 8 o'clock last night, we're not ready. Is that right?
I'm sorry, Your Honor.
No, don't address the court. Talk to me. Okay, quiet. Oh, even better. I'm sorry. Apparently, the court appointed hack has not done his job appropriately, and Mr. Schuff would like to go out and get a lawyer. If that's the case, Your Honor, I'd ask for this matter to be adjourned 2 weeks, and then we can make those arrangements. If those arrangements have not been made, then I can make a formal motion to the court to withdraw.
All right. Is that how you wanted to proceed today, Mr. Schuff?
Yes, Your Honor.
All right, you're charged with a 5-year felony crime of carrying a concealed weapon. The maximum crime is a felony. It carries a maximum penalty of 5 years in prison. The minimum sentence is discretionary with the court. The court will adjourn the status conference in this matter and schedule it to be heard at 9 a.m. on Tuesday, September 7, 2021. Don't let any grass grow under your feet, sir. If you want to hire a lawyer, get out there and find one and hire him or her. If you decide you want to stay with the lawyer who's been appointed, let him know that immediately. Thank you, sir, for being here. Make sure you're back here at 9 a.m. on Tuesday, September 7th, and make sure you follow all the terms and conditions of your bond.
Your Honor, if I could have a few moments, I know that Mr. White is here.
Sure.
Thank you.
Thank you. Mr. White, do you have any preference as to what order to call your cases in?
Oh, I do have Ms. Carlton here.
Thank you, sir. Calling the case of People versus Jessica Lee Carlton, file 21-6563-FH. Would counsel identify for the record, please?
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Ms. Carlton.
And Miss, are you Jessica Lee Carlton?
Yes, sir.
Previously, Ms. Carlton, you appeared in court, and at that time, you pled guilty to the 2.5-year felony crime, commonly known as attempted, I believe it's actually attempted conspiracy to furnish contraband to a prisoner. That crime is a felony. It carries a maximum penalty of 2 years and 6 months in prison, or 2.5 years in prison, and the minimum sentence is discretionary with the court. Do you understand those things, Miss?
Yes.
The Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 9 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. You understand those things, Miss?
Yes.
Mr. White, have you gone over these reports with your client?
I have, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict?
No, Your Honor, they appear to be adequate.
Do you have any challenges to the scoring of the offense variables or prior record variables or calculation as to the applicable sentencing guideline range as being 0 to 9 months?
No, Your Honor.
And on behalf of the people, Ms. Ambrositis, or is it Mr. Webb?
It's mine.
Thank you, Mr. Webb. On behalf of the people, Mr. Webb, is there anything, I would pose those same questions to you.
Thank you. I've reviewed the report. I have no additions or corrections to make to it. The guidelines are correctly scored.
Thank you, sir. Ms. Carlton, is there anything, ma'am, you want to say on your own behalf before the court passes sentence?
No, sir.
And on behalf of your client, Mr. White?
No, Your Honor, I would indicate to the court that the probation department has made a recommendation to the court, and I would ask the court to follow that recommendation.
Thank you, sir. And on behalf of the people, Mr. Webb?
I would also ask you to follow the plea agreement and recommendations from the probation department.
Ms. Carlton, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court you'll be placed on probation for a period of 2 years. In addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well. Those terms include, but are not limited to, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand. And you must successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must not use or possess any weapons or copies of weapons, and you must submit to a search of your person and property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe that you are conducting yourself in a manner inconsistent with the public good. You must abide by a curfew and be in your approved residence every day between 10 p.m. and 6 a.m. unless you first get written permission otherwise from the probation agent. You must seek and maintain full-time employment and/or be enrolled in a full-time education program. You must pay $68 in state costs and a crime victims assessment of $130. You must pay a supervision fee of $30 per month for the probation oversight fee, rising to $60 per month for any month during which you are under electronic monitoring supervision. You must pay court costs of $500 and a fine of $500 and court-appointed attorney fees of, do you have an estimate, Mr. White?
$450, Your Honor, $450.
$450. Now, how much of that $2,500 or so do you have available today to apply towards your court
I
order?
don't have anything.
Don't have anything at all, man?
I don't.
Well, let's see, you entered your plea
Well,
4 months ago, back on April 19th, right?
mhm.
And in the 4 months since then, you've raised precisely zero? Is that correct?
I get Social Security for my daughter, but that pays my mortgage. But I'm working on getting
I
the
believe
kids back.
you. I believe you. I'm just asking you, have you raised any money at all towards this court-ordered money?
No, sir.
How are you gonna be able to pay the $2,500 then while you're on probation, miss?
I applied for a couple jobs.
Well,
I had to,
that would certainly be a good idea to go get a job. And if the help wanted signs I've been seeing everywhere that I'm tripping over are any indication, you shouldn't have any trouble whatsoever finding a job. So you must pay $125 per month towards your court-ordered monies. And the first payment will be due by 12 noon on October 1st of 2021. And then an additional $125 minimum payment will be due by 12 noon on the first day of each and every month thereafter until paid in full, but all the money must be paid by the time you get off of probation. That will be the sentence of the court, miss. Now it's my duty now the final decision I have to make is how much jail time to send you to jail for. The Briggs-Killebrew agreement says I shouldn't put you in jail at all, but the sentencing guideline range is 0 to 9 months. I'm going to take a chance on you, and I'm going to honor the sentence cap. I'm not going to give you any jail time today, but I want you to be well aware, Ms. Carlton, if you violate your probation in a significant way and you're found guilty of that violation, I don't know what I would do at that point, but in all likelihood, I would send you to jail at least for the 9 months, and maybe I'd send you to prison. So you should be well aware you're on thin ice, yes. Now it's my duty to inform you that you are entitled to appellate review of your conviction and sentence. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal, but a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Thank you. Now, ma'am, it's my duty to inform you once again, you are entitled to appellate review of your conviction and sentence. And if you're financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. The record should reflect the defendant has received her copy of the advice of appellate rights form. She remains in possession of her copy, and she has signed the receipt form acknowledging those facts. The signed receipt form has been turned over to the court clerk. Your bond is canceled, miss, and any bond posted in your own name will be applied towards court-ordered money. Now that basically concludes our sentencing today, Ms. Carlton, but Agent Brubaker from the probation department might have some additional instructions for you. Agent Brubaker.
Thank you, Your Honor. Ms. Carlton, you need to contact Agent Eric Ween. I'm going to give you his phone number, and you need to call him by 4 p.m. today.
okay,
Are you ready for his phone number?
Yeah.
517-897-0354.
okay.
Thank you. I'm all set, Your Honor.
Thank you, Ms. Brubaker, and good luck to you, Ms. Carlton.
Thank you so much.
You're welcome, miss.
Thank you, Your Honor.
Thank you, Mr. White. Is that the last of your cases, or you have some others, but?
I do have Mr. Briggs, he's on Zoom, Your Honor.
Okay, thank you very much.
Thank you. Very well, then, calling the case of People versus Corey Lee Briggs, file 21-6651 FH. Would counsel identify for the record, please?
Sherman Besides Graham, yeah, people.
Good morning, Your Honor. Gerald White representing Mr. Briggs.
And sir, are you Corey Lee Briggs?
Yes, sir.
Would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Could you tell us your name, sir?
Corey Lee Briggs.
Today is the date and time scheduled for a status conference, and this might proceed, Mr. White.
Yes, this matter will be set over for pretrial, Your Honor. I have a pretrial summary in my possession from the prosecutor's office with an offer. I would also indicate that there is a request that the defendant have a CMH evaluation. That has been accomplished. I just received a copy of that report, and I've delivered a copy of that report to the prosecutor's office through Mr. Webb just today, personally hand delivered. So we will still be hopeful that we will still be negotiating on this matter.
Very well, then we'll schedule the case for a pretrial conference to be held at, what is your time, Mr. White?
Pardon me?
At 9:20 a.m. The pretrial will be held at 9:20 a.m., pretrial conference, 9:20 a.m. on Tuesday, September 7th. The bond status will be continued and the case is adjourned that date and time. Thank you.
Thank you, Your Honor.
Thank you, sir.
For the person whose telephone number ends in 537, please unmute and identify yourself for the court. Can you please unmute your microphone and identify yourself for the court? The other person is not connecting, so I don't have either of them, I guess.
Okay. Do you have anyone present in court that you wanted to go ahead with, Mr. White?
They're connecting.
Thank you.
May I approach?
Sure.
Can you please unmute your microphone and identify for the court? Your name, please?
Wendy Sue Kobrisky.
Okay, thank you. I'm going to put you in the waiting room until it's time for your hearing.
We'll be in recess then for a few minutes.
All rise. Who's presiding?
Good morning, you may be seated. Calling the case of People versus Lauren Dean Robinson, file 20-6309-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
So please, the court, Scott Moore for the defense.
Thank you. Mr. Robinson, would you please raise your right hand to be sworn, sir?
Your Honor, Mr. Robinson has failed to appear.
Oh, thank you. Thank you, Mr. Moore. The record should reflect Mr. Robinson was ordered to appear at 9 a.m. It's now almost an hour and a half past that scheduled time. It's 10:28 a.m. by the court's clock. Mr. Robinson has failed to appear. Do you know why that is, Mr. Moore?
I do not. I know that he had contacted my office last week and my secretary had spoken with him. I thought that we'd had a good line of communication going. When I asked for this matter to be passed, Ms. Keeley called 4 numbers that we had with Mr. Robinson. Only one was working. She did leave a voicemail. That was approximately half an hour ago. The other 3 phone numbers are no longer in service.
Thank you very well. The court will order Mr. Robinson to appear in person at 9 a.m. on Tuesday, September 7, 2021, to show cause why his bond should not be revoked and forfeited, and why he should not be charged with criminal contempt of court for his failure to appear here today. Thank you, Mr. Moore. The record should reflect it's now it's actually 10:29 a.m. by the court's clock, basically an hour and a half past the scheduled time, and Mr. Robinson still has failed to appear. Calling Calling the case of People versus Tyler Joseph Miller, file 20-6532-FH. Would counsel identify for the record, please?
John, besides screen, we have people.
Please, the court, Scott Moore for the defense.
How did you want to proceed, Mr. Moore?
Today is the time for sentencing. We're ready to proceed on that basis.
Thank you, sir.
Mr. Miller, do you waive your right to be sentenced in person? We go by Zoom.
Yes, sir.
Thank you.
Mr. Miller, you appear here today in file 20-6532-FC and in file 20- both in the same file, but in that file, you previously appeared in court back on July 7, 2021, and in this file, you pled guilty both to fleeing and eluding a police officer in the 3rd degree plus habitual offender second offense notice, and you also pled guilty to resisting or obstructing or assaulting a police officer plus habitual offender second offense notice. You appear here today to be sentenced. The maximum penalty the court could impose for the conviction of assaulting or resisting or obstructing a police officer ordinarily would be 2 years in prison. However, when coupled with a conviction for being a habitual offender second offense notice, as is the situation in which you find yourself, Mr. Miller, the net effect of that is that the court in its discretion could raise the maximum penalty from 2 years in prison to 3 years in prison. It would be discretionary with the court whether or not to raise the maximum sentence. And regardless of whether the court did so, the minimum sentence still would be discretionary with the court. In this same file, also on July 7, you appeared in court, and at that time you pled guilty to fleeing and eluding a police officer in the 3rd degree plus habitual offender second offense notice. You appear today to be sentenced for that conviction as well. Fleeing and eluding a police officer in the 3rd degree is a felony and normally would carry a maximum penalty of 5 years in prison, and the minimum sentence would be discretionary with the court. However, when coupled with a conviction for being a habitual offender, second offense notice, as is the situation in which you find yourself, Mr. Miller, the net effect of that is that the court once again could raise the maximum penalty. And in this case, the court could raise the maximum penalty from 5 years in prison to 7.5 years in prison. It would be discretionary with the court whether or not to raise the maximum penalty. And regardless of whether the court did so, the minimum then of each of these sentences would be discretionary with the court. Do you understand those things, Mr. Miller?
Yes, sir.
The Clare County Probation Department and the Michigan Department of Corrections have prepared a pre-sentence investigation report as well as 2 sentencing information reports. And in those reports, at least thus far, the departments calculate your applicable sentencing guideline range as to the fleeing and eluding a police officer in the 3rd degree, plus being a habitual offender second offense notice, as being 19 to 47 months. And the departments calculate your applicable sentencing guideline range as to the assaulting or resisting or obstructing a police officer plus habitual offender second offense notice. And the departments calculate the applicable sentencing guideline range for that offense, at least thus far, to be 0 to 3 months. You understand all those things?
Yes, sir.
Mr. Moore, have you gone over all of these reports with your client?
Yes, Your Honor.
Is there anything of a factual nature that you want to add to or explain or contradict in the pre-sentence investigation report or either of the sentencing information reports?
Mr. Miller has indicated to me that he believes that the agent's description of the offense is incorrect with regard to the number of times that he backed into the police cruiser. I think the better course would be, instead of asking for a change to that, I want it noted that that's the only factual issue my client has identified for me, and he can address that elocution. Thank you.
Is that what you want to do, Mr. Miller?
Yes, sir.
All right. Do you have any challenges, Mr. Moore, to the scoring of the offense variables or the prior record variables or the calculation as to the applicable sentencing guideline range being 19 to 47 months with regard to the conviction of fleeing and eluding in the 3rd degree plus habitual offender second offense notice, and with regard to the applicable sentencing guideline range being 0 to 3 months for the conviction of assaulting or resisting or obstructing a police officer, plus habitual offender second offense notice. Mr. Moore?
You know, on the face, Your Honor, these questions are quite simple, yet somehow I'm able to find places to poke. And I mean no disrespect to the agent who wrote the report. I know it has been the practice in this circuit to pay particular attention to the top charge, or the one with the greatest time required. We have no objection to the current offense guideline scoring for police officer fleeing third-degree vehicle code, habitual criminal, second offense notice. That does appear to be correct, and I know that I had consulted both with Agent Brubaker and the prosecutor's office. I am satisfied that the 19 to 47 range is correct. With regard to the second charge, it is clear that the prior record total and the offense variable total noted are incorrect. It should have been assessed at least 90 points for a total prior record total and 45 points for offense variable total. That should have no effect on the ultimate sentence, which I trust will be concurrent. But since the court asked specifically about the second charge, I am compelled to point this out. Thank you.
Thank you, sir. Do you want any change to be made as to the second count, the assaulting or resisting or obstructing a police officer plus habitual offender second offense notice?
The defense is not making that request primarily because it would be a difference without distinction.
All right. And there being no request for relief from the defense, Mr. Webb,
Mrs. Ambrositis.
Thank you. Mrs. Ambrositis, do you have any, I would pose those same questions to you with regard to the offense variables, the prior record variables, the calculation as to the guidelines and the contents of the re-sentence investigation report.
Thank you, Your Honor. We've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate with regard to the prior record variable score and the offense variable scoring for the fleeing and elude. Third, we find those to be accurate with regard to the prior record variable scoring and the offense scoring for the police officer resist and obstruct. Those are inaccurate, but if the court would score them at F3, it would move the 7 to 28 months.
I'm sorry, Miss, I had difficulty hearing the last thing you said. Are you asking then for changes to be made vis-a-vis the scoring of the sentencing information report with regard to the assault, the resist and obstruct, and the habitual offender second offense notice, Ms. Ambrositis?
Yes, the guidelines for that would be 7 to 28 months, not 0 to 3.
Okay. Do you contest that, Mr. Moore?
I do not.
All right, the court will change the guideline range from 0 to 3 months to 7 to 28 months. And with regard to the prior record variables, what, if any, PRVs should be changed, Ms. Ambrositis?
PRV 1 should be 25. PRV 2 should be 30. PRV 5 20.
Did you say PRV 5 should be 20 points?
Correct.
Thank you, Ms. Ambrositis. Any other changes to the PRVs?
PRV 6 should be 5. PRV 7 should be 10, for a total of 9.
Thank you, ma'am.
I agree with the total, Your Honor.
Okay, do you have any challenge? Do you disagree with any of the specific 5 changes to the PRVs?
I do not.
Thank you. The court will make those changes. PRV 1 will be 25 points. PRV 2 will be 30 points. PRV 5 will be 20 points. PRV 6 will be 5 points, and PRV 7 will be 10 points. The total prior record variable score will be 90 points, and the prior record variable level, instead of being level 1, will be, what would it be, Ms. Ambrositis?
So then the offense variables, number 13 would be scored at 10, 19 would be scored at 15.
Okay. Any other changes you're requesting? As to the offense variables?
No, and that would make it 25 points at level 3.
Thank you, ma'am. Do you agree, Mr. Moore?
I do, Your Honor.
Very well. The offense variables will be changed. OV 13 will be 10 points instead of 0 points. OV 19 will be 15 points instead of 0 points. The total OV points will be 25, and the OV level will be 3. And just to return for a moment to the appropriate prior record variable level, the total number of points is 90. The original PRV level was calculated to be level A. What is the actual PRV level as recalculated? Ms. Ambrositis, do you know, ma'am?
The PRV level for the RNO,
Yes, ma'am.
it's 90.
Would that be an F?
Yes,
Thank you.
Thank you, ma'am. So the cell into which the defendant now falls is cell F, Roman numeral 3, and the guideline minimum range is 7 to 28 months. Is that correct, Mr. Moore?
Yes, Your Honor.
And Ms. Ambrositis?
yes.
Thank you, ma'am. The court has made those changes and will direct the department to do so as well. Is there anything else either attorney would like to address regarding the sentencing information reports or the pre-sentence investigation report? Mr. Moore?
No, Your Honor.
Or Ms. Ambrositis?
No, thank you.
Mr. Miller, is there anything, sir, you want to say on your own behalf before the court passes sentence?
Yes, sir. I would just like to apologize to the county and all the officers of the fleeing and eluding not convicted that I wasn't thinking at the time that I ran, and I'd like to apologize to them and to the courts. And I'm just thankful that nobody got hurt during this time, and I'm hoping that I can move forward with my life. And I plan on, once I get back into the community, I plan on going to a sober living area. I'm hoping to go to another community so I can better myself and be able to be the father for my daughter that's 11 years old now and do the right thing this time. Thank you, Your Honor.
Thank you, sir. And on behalf of your client, Mr. Moore?
Thank you, Your Honor. We are asking the court to deviate from the recommended sentence, which calls for incarceration for a period of 19 to 47 months, which is 7.5 years. Instead, we ask the court to honor the Briggs-Killebrew agreement to 14 months in the Michigan Department of Corrections as the earliest out date, with the 7.5 years being maximum. Restitution is agreed to be $4,331.60. As I indicated earlier, my client disputes the number of times that he struck a police cruiser with his vehicle. Alternatively, his recollection of what happened that night is sketchy based on facts and circumstances of this case. But I am asking the court to note, and for the Department of Corrections to follow through with, Agent Brubaker noted in her evaluation plan, quote, there are concerns for his ability to be rehabilitated and that he should be assessed for D47 services by the parole board prior to his release, end quote. That is on page 2 of the CFJ 284. This is of the first moment, Your Honor. Well, certainly, there's no question that substance use disorder is part of this. My client does exhibit symptoms of traumatic brain injury. It has made his reintegration into society that much more difficult. It has been brought to my attention that the Department of Corrections, through this D47 classification, is able to provide enhanced services for rehabilitation of my client. And it is our sincere hope that the Department of Corrections exercises all due diligence in providing those services to Mr. Miller. He has expressed to me a desire throughout the pendency of this case to engage in services to benefit himself, to become a productive member of society, and to care for his 11-year-old daughter. Thank you, Your Honor.
Thank you, sir. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response. And on behalf of the people, Ms. Ambrositis.
Thank you. We ask that you follow the recommendations and the plea agreement in this matter. And I was going to ask to ensure that the restitution of $4,331.60 is added because I did not see that on CFJ 145, page 2. Mr. Moore mentioned it in his elocution as well. Thank you.
Thank you, Ms. Ambrositis. Very well, Mr. Miller, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you a chance to rehabilitate yourself for the conviction for fleeing and eluding a police officer in the 3rd degree, plus being a habitual offender, second offense notice. It's the sentence of the court that you be committed to the Michigan Department of Corrections for not less than 14 months and not more than 7.5 years. But you will receive credit for 244 days previously served for the underlying conviction of assaulting or resisting or obstructing a police officer, plus habitual offender, second offense notice. It's the sentence of the court that you be committed to the Michigan Department of Corrections for not less than 14 months and not more than 3 years. But you will receive credit for 204 days already served. Those two sentences will run concurrently to one another. They will run at the same time. In addition, you must comply with DNA testing and pay a $60 fee for that purpose. And you must pay $118 in state costs and a crime victims assessment of $130. Court costs of $500 and a fine of $500. And court-appointed attorney fees of, do you have an estimate, Mr. Moore?
Yes, Your Honor, $710.
Court-appointed attorney fees of $710. The court recognizes that it's discretionary with the court whether or not to raise the maximum end of each sentence or to keep the maximum ends at 5 years and 2 years respectively for the fleeing and eluding in the 3rd degree plus habitual second, and for the resisting or obstructing a police officer plus habitual second. But the court deems it to be appropriate to raise the maximum end of each one of those sentences, considering all of the circumstances of the crimes as well as, but not limited to, the defendant's prior criminal record as well. That will be the sentence of the court as to each of these two underlying convictions. And it's my duty to inform you, Mr. Miller, that you are entitled to appellate review of your convictions and sentences. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Bond is canceled, and any bond posted in the defendant's own name will be applied towards quarterly monies. Good luck to you, Mr. Miller. You are remanded to the custody of the Department of Corrections for the carrying out of the sentences. Those two sentences will run concurrently in one another. Calling the two cases of People versus Frank Mitchell Provence, file 21-6580-FH and file 19-6268-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
And please, the court, Scott, one for the defense.
Do you represent the defendant as to each one of these two cases, Mr. Moore?
Your Honor, I know that I have been substituted on pending felony charge. I think it was the intention of all parties that I also be appointed to the PB.
Okay, thank you. That will be the order of the court then. With regard to the probation violation matter, the 2019 file, Mr. White is relieved of his obligations in that file as well. Mr. Moore has been appointed, and this comes as no surprise to the defendant or Mr. Moore or Mr. White. That was their understanding coming into today's sentencings or proceedings. Is that correct, Mr. Moore?
As long as it's not sentencing, yes, that's our understanding. Yes.
Thank you, sir.
In connection with both files, Your Honor, counsel begs leave of the court for additional time to prepare. In that connection, I have been communicating with Agent Medley of the Department of Corrections and Lisa Ashley, the coordinator of the Recovery Court program, regarding potential admission of my client into that program. I've been advised that Mr. Provence is currently engaged in services with the 1016 Recovery Network. I've urged him to have a release of information signed at his earliest opportunity so that I can speak with them and then provide further information to DOC and Recovery Court. So for all of those reasons, Your Honor, we would ask for this matter to be placed on the next motion day or perhaps September 7th or whatever would suit the court's schedule. Thank you, Your Honor.
Thank you, sir. Very well. Any objection on behalf of the people?
Well, the only thing I'd like to put on the record, Your Honor, is that I think I discussed Recovery Court, or Mr. White approached me about Recovery Court a month or two ago. I have not made that referral, and so it's something I may consider, but I haven't committed to that. Other than that, I don't have an objection to the adjournment.
Very well, then we'll schedule the matters for a status at 9 a.m. in each file on Tuesday, September 7, 2021. The bond status will be continued. The cases will be adjourned at the date and time indicated. But Mr. Provence, make sure you stay in touch with Mr. Moore and make sure you follow all of the bond conditions. We'll see you back here then on September 7th.
There's a list of things to do.
Thank you.
I wasn't here.
Jail. I don't have a picture.
That's right. It was fine. It was fine.
Mr. White, calling the case of People versus Daniel Harley Tice, file 21-6648-FH. Would counsel identify for the record, please? Appearing on behalf of the people.
Sorry, Your Honor. Mark Webb on behalf of the people.
Thank you, Mr. Webb. And appearing on behalf of the defendant.
Gerald White, Your Honor.
Mr. Tice, would you please raise your right hand and be sworn, sir?
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Could you tell us your name, sir?
Daniel Harley Tice.
And are we proceeding by way of the guilty plea today, Mr. White?
We are, Your Honor. Thank you.
And do you know to what count or counts?
Yes, Your Honor. There's a pretrial summary that's been prepared by the prosecutor's office that I'm in possession of, and I've gone over it with Mr. Tice. In essence, the offer is that Mr. Tice enter a plea of guilty to the offense of possession of methamphetamine, count 1. And at the time of sentencing, the counts 2 and 3 would be dismissed. There's also a break to Killebrew agreement of no initial incarceration and a term of probation be placed against Mr. Tice.
Thank you, sir. Mr. Tice, do you understand, sir, that according to count 1, you are charged with the felony crime of possession of methamphetamine?
Yes.
Now, that crime is a felony and it carries a maximum penalty of 10 years in prison and or a fine of up to $15,000. And the minimum end of the sentence would be discretionary with the court. You understand those things?
Yes.
Now, there's no mandatory minimum sentence, but unless the court sentences you to more than 1 year in prison, then the court must suspend or revoke your driving privileges according to Michigan Compiled Law 333.7408A. Do you understand those things, sir?
Yes.
With regard to count 1, possession of methamphetamine, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas that you may make to count 1, possession of methamphetamine?
Yes.
Then answering to count 1, possession of methamphetamine, what is your plea, Mr. Tice?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes.
The court also informs you that if your plea of guilty to count 1 is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Now, do you understand all of those rights, sir?
Yes.
And do you understand that by pleading guilty to count one, that means you'll be giving up each and every one of those rights?
Yes.
Now, sir, I'm going to ask your lawyer, Mr. White, and the assistant prosecuting attorney, Mr. Webb, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement?
Your Honor, in exchange for the defendant's plea of guilty to count one, the possession of methamphetamine, I'll dismiss counts 2 and 3 at sentencing. And I will agree to a Briggs Killebrew sentence of no initial incarceration and a term of probation. If there's any restitution, that's to be determined.
Mr. White, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Tice, did you hear what your lawyer or the prosecuting attorney said the plea agreement is?
Yes, Your Honor.
Did you understand the plea agreement, sir?
Yes.
And are you in agreement with that plea agreement?
Yes.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count one, possession of methamphetamine?
No, sir.
So for example, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or threatened your family to get you to plead guilty, sir?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir.
Now, do you have any questions about what the court has told you, Mr. Tice?
Sir.
Do you understand everything that the court has told you, sir?
Yes.
In light of everything that the court has told you, do you still want to plead guilty to count one, possession of methamphetamine?
Yes, sir.
Then, sir, drawing your attention back to on or about April 24 of 2021, were you in Lincoln Township in Clare County, Michigan?
Yes, sir.
On that day and at that location, did you have some methamphetamine in your possession?
Yes.
Now, at the point in time when you possessed the methamphetamine on that day, did you know that it was methamphetamine?
Yes, sir.
Okay, and did you have any legal right or justification or mitigation that allowed you to possess the methamphetamine?
No, sir.
But you went ahead and possessed it anyway, is that true?
Yes, sir.
Mr. White, are you satisfied there's a sufficient factual basis to accept the defendant's plea of guilty to count one, possession of methamphetamine?
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Mr. White, has the court complied with the court rule and the taking of the plea?
Yes, Your Honor.
Do you agree, Mr. Webb?
You have, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty to count one is accepted and ordered entered on the records of the court. Sentencing will occur at 9:20 a.m. on Monday, October 4, 2021. Bond is continued and the case will be adjourned to the date and time indicated. Now, Mr. Tice, that basically concludes the plea-taking process, but the probation agent, Ms. Brubaker, might have some additional instructions to give to you. Agent Brubaker, do you have any such instructions?
Thank you, Your Honor. Mr. Tice, wait in the hallway after you're done with court. I'm gonna come up and see you with some paperwork, okay?
Okay.
Thank you, Your Honor.
Thank you, ma'am. We'll be in recess in that matter then. Good luck to you, sir.
May I address another matter? There was also a notice for Mr. Tice when he failed to appear at a particular court hearing back on July 19. And I would indicate to the court that Mr. Tice on the 19th, he was on Zoom for an extended period of time and was knocked off of the Zoom and did not appear. The judge removed issued the bench warrant for failure to appear. Then later on August 2nd, he was to appear again for this same plea. And then the court server went down. And so that's why it was moved to today's date. But I wanted the court to understand that he did not fail to appear. It was not his fault. So I want the court to be aware of that.
Thank you, Mr. White. In light of your explanation and in light of the fact that the defendant did appear here in person on time as ordered to do so, the court is going to dismiss without prejudice its order that the defendant appear here today to show cause why he should not be held in criminal contempt of court for allegedly failing to appear in court previously as ordered. So I will dismiss that proceeding. Now, when you come back here, sir, on October 4th, you could be put in the state's prison, or you could be sent to the county jail for up to a year, or something else might happen. But one thing that will happen, which is I'm telling you what will happen, is you'll be ordered to pay some court-ordered money that will add up to about $2,500. You now have another month and a half or so to take legal steps to raise that money and have it available to you when you return here on October 4th. Good luck to you, sir.
Thank you.
You're welcome.
Thank you, Your Honor.
Judge, because the parties here in person, that
Calling the case of People versus Wesley Alva Walker, file 21-6676-FH. Would counsel identify for the record, please?
Chambers, I speak on behalf of People.
Good morning, Your Honor. Anthony Jenkins appearing on behalf of Mr. Wesley Walker, who's appearing to my left.
Thank you, Mr. Walker. Would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Could you tell us your name, sir?
Wesley Alva Walker.
Here, this is set for a pre-trial in this matter. We're not prepared today to take a plea if that's not the court's heading in that direction.
Okay, thank you, Mr. Jenkins. Mr. Walker, do you understand that according to count 1, you were charged with the 10-year felony crime commonly known as discharging a firearm in or at a building?
Yes, sir.
That crime is a felony, carries a maximum penalty of 10 years in prison and/or a fine of up to $10,000, plus there will be mandatory forfeiture of the weapon. Do you understand those things, sir?
Yes, sir.
The minimum sentence would be discretionary with the court as to count 1. Do you understand any as well.
Yes, Your Honor.
With regard to count 2, you are charged with the 90-day misdemeanor crime of reckless use of a firearm. That crime is a misdemeanor. It carries a maximum penalty of 90 days in jail and/or a fine of up to $500. And in addition, the court may suspend your hunting privileges for up to 3 years. And the minimum end of that sentence also is discretionary with the court. Do you understand those things, sir?
Yes, sir.
Are you asking for a jury trial as of now, Mr. Jenkins?
We are, Your Honor.
And how many days do you think that jury?
That's a 1 to 2 days is the pretrial as indicated, Your Honor.
Thank you, sir. Is there anything else you wanted to address today, Mr. Jenkins?
No, Your Honor, thank you.
Is there anything else you wanted to address today, Ms. Ambrositis?
Nothing further, Your Honor.
Thank you, ma'am. Very well, then the case will proceed to jury trial or other disposition, and the bond will be continued. Mr. Walker, make sure you stay in touch with your lawyer and make sure you follow all of the conditions of your bond.
Yes, sir.
Thank you for being here, sir.
Yeah, thank you. Thank you, Your Honor.
We'll be in recess on that matter. Sure. Calling the case of People versus Melissa Ann Ofalu, file 21-6613-FH. Would counsel identify for the record, please?
Mr. Ambrositis, bring it up, people.
Good morning, Your Honor. Joseph Duso on behalf of the defendant.
Are you Melissa Ann Ofalu?
I am, Your Honor.
Am I pronouncing your name correctly, Ms.?
Yes, sir.
Ms. Ofalu, back on June 21 of 2021, you appeared in court, and at that time, you pled guilty to 2 separate 4-year felonies. You pled guilty to welfare fraud over $500 and welfare fraud failure to inform of $500 or more. You appeared here today to be sentenced. Each one of those convictions carries a maximum penalty of 4 years in prison, and the minimum sentence as to each count is discretionary with the court. Do you understand those things, ma'am?
Yes, Your Honor.
The Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those 2 reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 6 months, although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, Ms. Ofalu?
Yes, Your Honor.
Mr. Duso, have you gone over those reports with your client?
We have, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict, sir?
Nothing factually.
Do you have any challenges to the scoring of the offense variables or the prior record variables or the calculation as to the applicable sentencing guideline range as being 0 to 6 months?
No challenges, Your Honor.
And Ms. Ambrositis, on behalf of the people, I would pose that same series of questions to you, ma'am.
Your Honor, we've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. We reviewed the prior record variable scoring and the offense variable scoring and find those to be accurate as well. The only thing I would point out on page 3 of CFJ 145 is that paragraph 22 is asking for attorney fees of $500, but I do believe that Mr. Dussault is retained, and so
That's
those would not
correct. I was gonna ask that that be corrected as well.
Thank you, Mr. Dussault. Thank you, Ms. Ambrositis. The court will make that change by deleting the recommendation in paragraph 22 on page 3 of the CFJ 1445. That would be the recommendation as to court-appointed attorney fees. Anything further, Ms. Ambrositis
No, thank you, Your Honor.
or Mr. Dussault?
As to the recommendations, I do have, just want to get one point of clarification as to recommendation number 24 on page 3, referring to not to use, purchase, or possess recreational marijuana. I want it clear that that does not apply to a valid medical marijuana patient. Is that correct?
Is that correct, Agent Brubaker?
That is correct. That has been removed from our conditions for about a month and a half now.
Okay, thank you, ma'am. Yes, you are correct. Mr.
Okay.
Dussault.
I have nothing further on the reports then.
Thank you, sir. Ms. Ofalu, is there anything, ma'am, you want to say on your own behalf before the court passes sentence?
Yes, Your Honor. Your Honor, I'd like to apologize for my mistake. I take full responsibility for my failure to turn my paperwork on time. I realize that my mistake led to my being issued too many food stamps, and I brought the money today to pay for those. I shouldn't have brought them, and I'm really sorry for all of this.
Thank you, ma'am. And on behalf of your client, Mr. Dussault?
Thank you, Honor. Yeah, as my client acknowledges, she made a mistake. She failed to inform the state that she had returned to work after being off for medical. And as she stated, she takes full responsibility for it. She is fully employed. She's been with the same employer for the past 3 years. She's married. She's finally got her last son out of the house now. He's graduated. She's helping to take care of her family. She's got her mother living with her and her sister. She's a hard worker that made a mistake here. We would ask the court to follow the recommendation of the delay sentence with the grace period rule for no initial incarceration. The recommendation is for 12 months. Ms. Ofalu has come here today ready to pay the full restitution. And I believe when taking into consideration the bond money as well, she may be able to pay that as well as fines and costs, depending on how high your fines are that you assess today. In light of her coming here today to make full restitution, I'd ask that you consider a lower delay of sentence than 12 months. This was a mistake by a hardworking blue-collar worker. And I'd ask that you follow the recommendations. Thank you.
Thank you, Mr. Dussault. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response. And on behalf of the people, Ms. Ambrositis?
Thank you. We ask that you follow the recommendations in the plea agreement in this matter.
Thank you, ma'am. Very well, Ms. Ofalu, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court that you'll be placed on what is commonly called delayed sentence probation for up to 1 year. In addition to all of the statutory terms of probation, you also must abide by all the written terms of the probation order as well, which include but are not limited to: you must not use or possess any controlled substances or drug paraphernalia, You must submit to drug and alcohol counseling on demand, and you must submit to drug and alcohol testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not use or possess any weapons or copies of weapons. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, and you must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must submit to a search of your person and property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must pay restitution of $3,253. You have that money available today, ma'am?
Yes, Your Honor.
All right, that must be paid today then by 3 p.m. And further, you must surrender all tax refunds towards any monies owed to the court. And you must pay $136 in state costs. You must comply with DNA testing, and you must pay a crime victims assessment of $130. While you're on probation, you must pay a supervision fee of at least $30 per month, rising to $60 per month for any month during which you are on electronic monitoring supervision. You must pay court costs of $500 and a fine of $500. That will be the terms of the delayed sentence probation. Because I have not imposed a final sentence, there's no need to advise you of any appellate rights because they don't get attached. We'll have you come back, ma'am, on the first motion day in May of 2022 to be sentenced for the final sentencing. And are there any further instructions you wanted to give to Ms. Ofalu, Ms. Brubaker?
Yes, thank you, Your Honor. Ms. Ofulu, you need to contact Agent Eric Lean by 4 p.m. today. I'm going to give you his phone number. Are you ready?
Yes, she's ready.
517-897-0354. Thank you, Your Honor.
Thank you, Agent Brubaker.
Can she repeat the last name of the agent?
Ween, W-E-N.
Thank you, Your Honor.
Thank you, thank you, sir. And thank you, Agent Brubaker. Now, Ms. Ofalu, you're going to pay the court-ordered restitution today, correct?
Yes.
Now, in addition, there was $136 in state costs and $130 in crime victims assessment. And then $500 court costs and a fine of $500, which is going to add up to about another $1,700 or so. How long would it take you to pay that, ma'am?
I'm not sure how much I have for my,
Sure, take your time, miss.
$750 bond posted, so $675. Can you apply?
So you'd have to come up with about another $1,000.
I believe I could have that at the end of the day, Your Honor.
All right, then I will order that you pay all the court-ordered monies in full by 3 p.m. today. And that will be a condition of your delayed sentence on probation or department. Thank you, ma'am. And make sure you contact Agent Ween before the end of the day as well. Thank you, Ms. Okalu, and good luck to you, miss.
Thank you.
Thank you.
So, calling the case of People versus Courtney Michelle Metcalf, file 19-6270-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Ms. Metcalf just went to the restroom. She should be back shortly.
Okay, thank you.
Thank
Mr.
you for
Gilbert.
calling it early, Your Honor.
That's okay. Thank you, Mr. Gilbert. Mr. Moore, I've been avoiding dealing with your cases. But do you have a preference as to which cases to call next? Is it just the DOS matter?
I think Mr. Wood was on the docket for today,
Okay.
and we will be waiving his appearance. He is live.
Thank you, sir. Calling the case of People versus David Matthew Wood, file 20-6461-FH. Would counsel identify for the record, please?
Sure, besides appearing of the people.
Please, the court's got more for the defense.
In this case, I believe we were having a status conference, and was this regarding the status of the defendant's examination by the forensic center, Mr. Moore?
That's correct, Your Honor. I do note that Attorney Gerald White filed a notice of insanity defense on June 16th, 2021. The court ordered evaluation relative to criminal responsibility as required by statute. The order was entered, I believe, on June 18th. To the best of my information, knowledge, and belief, the order has been forwarded to the Center for Forensic Psychiatry. I will follow up to confirm that, but at this time, neither Attorney White nor myself have received a response or a scheduling notice from forensics, which is not unexpected, given that they have at least 60 days to provide that.
Thank you, sir. Very well, then, you want the matter just to be scheduled for a status conference in November or so?
We could go that long, certainly. Or if it wouldn't overburden the docket, perhaps in another month, just to make sure that we're on track, because that will put us in that 60-day range.
Okay. Very well, then, we'll schedule the case for a status conference at 9 a.m. on Monday, October 4, 2021. The bond status will be continued. The case will be adjourned at the date and time indicated. And Mr. Moore, if you believe it to be appropriate to address the case before then, feel free to just bring that to the attention of the court or the assignment clerk.
Well, thank you.
Thank you. The bond status will be continued. And calling the cases of People versus Johnny Dwayne Doss, file 20-6479-FH and file 21-6611-FH. and file 21-6612-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
This court, Scott Moore for the defense, and don't believe Mr. Doss has been conducted to the zero.
Okay, we'll pass on the DOS matter then, DOS matters. And were you ready on your matter, Mr. Gilbert?
I am, Your Honor.
Thank you. Calling the case of People versus Courtney Michelle Metcalf, file 19-6270-FH. Counsel identify for the record, please.
Good morning, Your Honor. May I please Court Attorney David Gilbert bring on behalf of Ms. Metcalf. Ms. Metcalf is in the courtroom, standing immediately to my left. Could you identify yourself for the record, please?
Courtney Michelle Metcalf.
Good morning, Ms. Metcalf.
Good morning.
Previously, back on July 20th, 2020, you appeared in court, and at that time, the court placed you on what's commonly known as delayed sentence probation. You appear here today for the final sentencing. The Department of Corrections and the Clare County Circuit Court Probation Department has recommended that they've prepared an updated evaluation and plan. And in that updated evaluation and plan, the department recommends that basically they point out that you allegedly have not paid all the court-ordered money you were ordered to pay. You have a remaining balance of almost $2,000, and your last payment was made 5 months ago in March of 2021, but that you otherwise have complied with the terms of the delay of sentence probation, and the department recommends the plea agreement be followed, which would entail setting aside the plea of guilty to the 2-year felony crime of resisting or obstructing a police officer and entering in its place a plea to the 1-year plea of guilty to the 1-year misdemeanor crime of attempted assaulting or resisting or obstructing of a police officer. Ms. Ambrositis, do you have any objection to that procedure?
Members Asprey, on behalf of the people, we do not, Your Honor.
Thank you, ma'am. Is that what you are asking the court to do as well, Mr. Gilbert?
I am, thank you, Your Honor.
Very well. The court will set aside the previously entered plea of guilty to the felony crime of assaulting or resisting or obstructing a police officer and enter in its place a plea of guilty to the 1-year misdemeanor crime of attempted resisting or obstructing of a police officer. And I will use as a factual basis for the misdemeanor plea the previously entered felony plea entered back in July of 2020. Do you have any objection to that procedure, Mr. Gilbert?
No objection, Your Honor.
Or Ms. Ambrositis?
No objection, Your Honor.
And Mr. Gilbert, is there, well, first, do you have any objection to the court proceeding immediately to sentence?
I do not.
Do you have any such objection, Ms. Ambrositis?
No, Your Honor.
All right, Ms. Metcalf, is there anything else you want to say on your own behalf before the court passes sentence?
I wasn't able to pay my fine because my second job, I lost it because of this charge. And I've been staying in a hotel room, so I haven't had to pay that. So I haven't really had a chance, but when I did have extra money in March, I did pay $500 on it.
Thank you, Ms. Anything else you wanted to say, ma'am?
No?
All right, and on behalf of your client, Mr. Gilbert?
On behalf of my client, I'd ask that the court follow the agreement. However, just a brief commentary. I am surprised that I am not dodging books from the bench this morning as Judge Toy. That book at me and my defendant. We have put this court through every conceivable delay possible, and I apologize for that. And my final portion of that, I totally dislike Zoom. But I thank the court. I am impressed that I have not been dodging books. Thank you.
Thank you, Mr. Gilbert. And on behalf of the people, Ms. Ambrositis?
Your Honor, we ask that you follow the agreement and the recommendations. I don't believe that she needs to be placed on or, incarcerated at all. And I don't believe she would need to be placed on probation as long as she continues to make the payments.
Thank you, Ms. Ambrositis. Very well, Ms. Metcalf, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court. I'm going to sentence you to pay all the fines and costs and fees and restitution that you previously were ordered to pay. I'm not going to give you any jail time today, and I'm not going to continue you on probation for today, but you owe another $1,900 some dollars. And Miss, how long do you think it's going to take you to pay that money?
I can probably pay like $100 a week.
A week or a month?
A week.
Are you sure of that, ma'am?
I'm certain.
Okay. What I'm going to do then is this. I'm going to order that you pay at least $50 per week until this money is paid. And you currently owe $1,977.60. If you can pay $100 a week, that's even better. Because then at the end of 20 weeks, you'll be out from under this case. Now, you're not on probation. So, but you still have to pay this money, and if you don't pay it, you can be held in contempt of court. You could wind up being put in jail for 30 days at a time until you pay that money. And that can happen indefinitely over and over again. You've been very responsible thus far in how you've handled this once you got yourself into this situation. So I can compliment you on that, and I just urge you, don't falter in the home stretch here. Just make sure you pay that $2,000 or so, okay? That will be the order of the court. The court does note that if there's any question, normally the court only places someone on delayed sentence probation for a period of up to 1 year. And there used to be Court of Appeals case law to the effect that after the end of that 1 year period, if the court had not imposed a final sentence, that it was stripped of its jurisdiction. However, the court does note that the Michigan Supreme Court has redressed that opinion from the State Court of Appeals, which this court disagreed with for whatever it's worth. And the court agrees with the ruling of the Michigan Supreme Court. I'm sure they'll breathe a sigh of relief in that regard. And that's pursuant to the case of People versus Smith, docket number 147187, decided back on June 18 of 2014. Good luck to you, Miss. You're welcome. It is my duty to inform you that you are entitled to appellate review of your condition and sentence. If you're financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect effect an appeal, but a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Please sign the receipt form, which is your acknowledgement that you received your copy of the advice of appellate rights form. Record should reflect the defendant has received her copy of the advice of appellate rights form. She remains in possession of her copy, and she has signed the receipt form acknowledging those facts. The signed receipt form has been turned over to the court clerk. And Miss, you are free to go. Good luck to you and congratulations. Thank you, Mr. Gilbert.
Thank you, Your Honor.
Calling the case of People versus Adam Jerome Bugnacki, file 21-6683-FH. Could you tell us your name, sir?
My name is Adam Bugnacki.
Could you repeat your last name?
Bugnacki.
Thank you, Mr. Bonacki. And appearing on behalf of the people.
Besides on behalf of people.
Thank you. Mr. Bonacki, do you have a lawyer representing you in this case?
Yeah, he's up on the Zoom.
Thank you. And appearing on behalf of the defendant.
Attorney Joe Blata, good morning.
Good morning, sir. Today is the date and time scheduled for a pretrial conference. Did you want to proceed by pretrial conference or by guilty plea on behalf of the defense?
Discussed the offer with Mr. Bugnacki this morning. I just got the pretrial offer form this morning as well, and he would like to enter into the agreement that Ms. Ambrositis has offered today, Your Honor.
Thank you, sir. Is that correct, Mr. Bugnacki?
Yes, Your Honor.
Bugnacki, do you understand, sir, that according to count one, you are charged with the 5-year felony crime commonly known as operating a motor vehicle while intoxicated?
Yes, Your Honor.
Now, sir, that crime is a felony and it carries a maximum penalty of 5 years in prison, and the minimum sentence is discretionary with the court. It also carries a maximum fine of between $500 and $5,000. Do you understand those things?
Yes, Your Honor.
With regard to count one, operating a motor vehicle while intoxicated, third offense, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count one, operating a motor vehicle while intoxicated? Third offense notice, Mr. Bugnacki.
Yes, Your Honor.
Then answering to count one, what is your plea?
My plea is guilty.
Sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, Your Honor.
The court also informs you that if your plea of guilty to count one is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt.
Yes, Your Honor.
Thank you, sir. the right to have all of the witnesses against you to appear at the trial and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial, and if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of those rights, Mr. Bunaki?
Yes, Your Honor.
And do you understand, sir, that by pleading guilty to count one, that means you'll be giving up each and every one of those rights?
Yes, Your Honor.
Now, sir, I'm going to ask your lawyer and the elected prosecuting attorney for Clare County, Ms. Michelle Ambrositis, to tell us what the plea agreement is. And I want you to listen to both of them very carefully. Ms. Ambrositis, what is the plea agreement?
In return for the defendant's guilty plea to operating while intoxicated, third offense, the people would move to dismiss the remainder upon sentencing and running the appropriate appeals period. There is an agreement pursuant to Briggs and Killebrew that this would be a sentence at the bottom end of MDOC guidelines. $35 restitution for the blood draw, $150 for costs of law enforcement, actual cost of prosecution to be ordered, day-for-day credit for inpatient treatment successfully completed.
Mr. Blada, is that your full and complete understanding of the plea agreement as well, sir?
It is, Your Honor.
Mr. Bunaki, did you hear what the prosecutor and your lawyer said the plea agreement is, sir?
Yes.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count one?
No, Your Honor.
So for example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No.
Has anyone threatened you or threatened your family to get you to plead guilty, sir?
No, Your Honor.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still want to plead guilty to count one, operating a motor vehicle while intoxicated through the fence?
Yes, Your Honor.
Then, sir, drawing your attention back to March 3rd of 2021, were you in Lincoln Township in Clare County, Michigan on that day?
Yes, Your Honor.
On that day and at that location, were you driving a motor vehicle on Hemlock Road near Mansiding Road?
Yes.
And Hemlock Road is a highway, a public highway, correct?
Yes.
Were you also driving a motor vehicle on Hemlock Road? Well, you've already indicated it was near Mansiding Road, correct?
Yes, Your Honor.
Now, before, what kind of a motor vehicle were you driving, sir?
Buick Rendezvous.
Before you drove that Buick Rendezvous sports utility vehicle, had you been drinking some alcohol?
No, Your Honor.
Had you consumed a controlled substance?
Yes, Your Honor.
What was the controlled substance that you consumed?
Adderall.
And were you under the influence of Adderall at the time you drove the Buick Rendezvous?
Yes, Your Honor.
Did you?
Yes.
Thank you, sir. And sir, drawing your attention back to on or about September 28th of the year 2012, in the Third Circuit Court here in the state of Michigan, were you convicted of the crime of operating a motor vehicle while intoxicated?
Yes.
And drawing your attention also to August 17 of 2012 in the Third Circuit Court here in the state of Michigan, were you also convicted of the crime of operating a motor vehicle while intoxicated?
Yes, Your Honor.
Are you satisfied, Mr. Blada, that there's a sufficient factual basis to accept the defendant's plea of guilty to count one?
I am, Your Honor.
You agree, Ms. Ambrositis?
Yes.
Mr. Blada, has the court complied with the court rule in the taking of these, this plea?
I believe so, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Very well, then, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty to count one, operating a motor vehicle while intoxicated, third offense is accepted and ordered entered on the records of the court. Sentencing will occur at 11 a.m. on Monday, October 4, 2021. Bond is continued and the case will be adjourned to the date and time set for sentencing. When you come back here at that time, sir, you could be put in prison or you could be put in county jail for up to a year, or something else might happen. But one thing that will happen is you'll be ordered to pay some court-ordered money that will probably add up to right around $2,200. You now have another 7 weeks or so to take legal steps to raise that money and have it available to you when you come back here to be sentenced. That will conclude the plea taking, but Agent Caitlin Brubaker from the probation department might have some instructions to give to you. Agent Brubaker.
Thank you, Your Honor. Mr. Bognacki, if you could just wait in the hallway for me after court, I will bring up some paperwork and give you further instructions, okay?
Thank you.
Thank you, Your Honor.
Thank you, ma'am. We'll be in recess on your case then, Mr. Bognacki. Thank you, Mr. Blada. We'll be in recess on that case.
Thank you, Judge.
Calling the case of People versus Cassie Marie Elliott, file 20-6400-FH, with counsel identified for the record, please.
Sorry.
Hello. All right, did you call the Elliott case?
Yes, sir.
All right, sorry, Judge. Yeah,
That's okay.
right here.
That's okay, Mr. Dietrich. Assistant Prosecuting Attorney Mark Webb has entered his appearance on behalf of the people, and appearing on behalf of the defendant is Defense Attorney D. Todd Dietrich. Ms. Elliott, would you raise your right hand to be sworn, ma'am?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name?
Casey Elliott.
You may lower your hand if you'd like, Ms. Elliott. Good morning to you. How did you want to proceed today, Mr. Dietrich?
Your Honor, this case stems from some new charges that are currently in district court, and I would request that this matter be adjourned out for approximately 45 days if possible.
All right. Any objection to that, Mr. West?
No, Your Honor.
We'll adjourn the status conference until 10:40 a.m. I'm sorry, until 9:40 a.m. on Monday, October 4th, 2000. Status will be continued. The case will be adjourned to the date and time indicated. But you'll have to come back at that time, Ms. Elliott. And you also must obey all the terms and conditions of your bond, and your probation order as well. Thank you.
I apologize, Your Honor. Right as you said the date, a car went by with a very loud muffler. I missed the date.
It will be Monday, October, thank you, Mr. Dietrich. Monday, October 4th at 9:40 a.m.
All right, thank you very much, Your Honor.
Thank you, Mr. Dietrich. We'll be in recess in that matter then.
Thank you.
Calling the case of People versus Joshua Joseph Eaton, file 21-6604-FC. Would counsel identify for the record, please?
Scott Moore for the defense, Your Honor. It is.
And Ms. Zambrositis, do you appear on behalf of the people? You want me to pass on this matter? Go back to the Ross cases?
As the assistant prosecutor, and I could approach.
Sure.
And I don't think we need his presence.
Regarding the case of People versus Joshua Joseph Eaton, 521-6604-FC, the court has conducted a sidebar conference with Assistant Prosecuting Attorney Mark Webb and the defense attorney. The court will schedule
The continued status conference.
this continued status conference to be conducted on Tuesday, September 7 at 9 a.m. The bond will be continued, bond status, and the case will be adjourned to the date and time indicated. Calling the case of People versus David Matthew Wood, file 20-6461-FH. Would counsel identify for the record, please?
Your Honor, Scott Moore for the defense. We addressed this earlier with Mr. White.
Thank you, Mr. Moore. That matter has been addressed then. And recalling then the cases of People versus Johnny Dwayne Doss, file numbers 20-6479-FH and 21-6611 and 6612-FH.
Your Honor, please the court, Mr. Doss has been conducted to the.
Thank you, Mr. Moore. And appearing on behalf of the people.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Please the court, Scott Moore for the defense.
Council approach to them.
Thank you.
So are you Johnny Dwayne Doss?
Yes, sir.
Today is the date and time scheduled for sentencing in file 20-69-FH, of course, and file numbers 21-6611 and 6612-FH. How would you like to proceed, Mr. Moore?
Thank you, Your Honor. I will be taking these out of order. With regard to file 21-6611-FH, it is my understanding we will be proceeding on count 1 as an habitual second.
Count 1 and habitual second. Okay.
That's right.
But there are amended informations that need to be filed in these matters that are not yet filed. Is that true?
That's correct, John.
That's right. Also, we will be proceeding in 21-6612-FH on count 1, again as an habitual second, and amended information will have to be prepared for that. Finally, Your Honor, we are also here today for sentencing 20-6479-FH. Offense is in receipt of the pre-sentence investigation report of the client. Assuming that the pleas are accepted by the court, we would suggest that this sentencing be adjourned to the same sentencing day as the other 2 files.
Thank you. Very well then, in the 2021 cases, the court will schedule those matters for pleas to be entered at 9 a.m. on Monday, October 4th, 2021. With regard to the sentencing in the 2020 case, we'll adjourn that sentencing without date. The bond status will be continued in all of these matters.
Your Honor, may we approach?
Sure. Mr. Doss, change in plan. We're going to go ahead with the arraignments today. Sir, would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
Could you tell us your name, sir?
John Doss Jr.
Mr. Doss, in file 21-6612-FH, do you understand, sir, that according to count one, you are charged with delivery or possession with intent to deliver the controlled substance methamphetamine.
Yes, sir.
Now, that crime is a felony, and ordinarily it would carry a maximum penalty of 20 years in prison and or a fine of up to $25,000. You understand those things?
Yes, sir.
But in addition, you are charged with being a habitual offender, second offense notice. So as a consequence, if you plead guilty both to count one, possession of methamphetamine with intent to deliver, and you also plead guilty to being a habitual offender, second offense notice, the net effect of those things is that the court, at its discretion, could raise the maximum penalty from 20 years in prison to 30 years in prison, and it could raise the maximum penalty vis-a-vis or with regard to the fine from $25,000 to a fine of up to $37,500. Do you understand those things?
Yes, sir.
It would be discretionary with the court whether or not to raise the maximum end of the sentence. And regardless of whether the court did so, the minimum end of the sentence still would be discretionary with the court. Do you understand those things?
Yes, sir.
Turning to file 21-6611-FH, do you understand, sir, that according to count one, you are charged with the crime commonly known as possession of a stolen or false or counterfeit registration plate and registration tab?
Yes, sir.
Now, that crime is a felony and ordinarily would carry a maximum penalty of from 1 to 5 years in the state's prison and a fine of up to $500 to $5,000. You understand those things?
Yes, sir.
But do you also understand, sir, that in that file as well, you are charged with being a habitual offender, second offense notice?
Yes, sir.
As a consequence, sir, if you plead guilty both to count one and to being a habitual offender, second offense notice, the net effect of those things is that the court in its discretion could raise the maximum penalty to 18 months to 7.5 years in prison and could raise the maximum fine to $750 to $7,500. Do you understand those things?
Yes, sir.
It would be discretionary with the court whether or not to raise the maximum end of the sentences. And regardless of whether the court did so, the minimum end of the sentence still would be discretionary with the court within the parameters set by law. Do you understand those things?
Yes, sir.
Now, with regard to count one in each of these two files, and also with regard to being a habitual offender, second offense notice in each of these two files, it would be discretionary. You, with regard to all four of those pleas, or all four of those matters, you may make any of the following three pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to these four matters, Mr. Das?
Yes, sir.
Then starting with file 21-6612-FH, answering to count 1, possession of methamphetamine with the intent to deliver it. What is your plea?
Guilty.
And answering in that same file to being a habitual offender, second offense notice, what is your plea?
I'm guilty, sir.
Turning to file 21-6611-FH, answering to count 1 in that file, possession of a stolen or false or counterfeit registration plate and registration tab. What is your plea?
Still guilty, sir.
And answering to being a habitual offender, second offense notice in that file, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentences will be?
Sir.
Do you understand that, sir?
Yes, sir.
Thank you, sir. The court also informs you that if your pleas of guilty are accepted, then that means you won't have a trial of any kind in either of these two files, and you therefore will be giving up each and every one of the following rights in both of these two files. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial, and if you choose to do so, and your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Das?
Yes, sir.
And do you understand, sir, that by pleading guilty, that means you'll be giving up each and every one of those rights?
Yes, sir.
Now, I'm going to ask your lawyer, Mr. Moore, and the assistant prosecuting attorney, Mr. Webb, to tell us what the plea agreement is, and I want you to listen to both of them very carefully, Mr. Das. Mr. Webb, what is the plea agreement in these two cases?
Judge, starting with file 21-6612FH, it's my understanding the defendant will plead guilty to count 1, possession with intent to deliver methamphetamine as a habitual second offender, dismiss the rest at sentencing, including I believe it's a half third.
Yes.
And recommend 24 months with the Michigan Department of Corrections. And file 21-6611FH, he'll plead guilty to count 1 as a habitual second offender. I'll dismiss counts 2 and 3 and the habitual third offender at sentencing, and recommend a year for the statute in that charge, and that would run concurrent with the other cases.
And Mr. Moore, is that your full and complete understanding of the plea agreements? The plea agreement, pardon me.
I would seek a clarification as to the nature of the sentence bargain, whether that's a recommendation or an agreement pursuant to People versus Briggs.
Was that for example?
Yes, sure.
Each file, Mr. Webb?
Yes, sir.
Thank you. With that clarification, Mr. Moore, is that your phone complete understanding of the plea agreement?
It is, sure.
Mr. Das, did you hear what Mr. Webb and Mr. Moore said the plea agreement is?
Yes, sir.
Did you understand the plea agreement?
Yes, sir, I do.
And do you agree with this, sir?
Yes, sir.
Has anyone promised you anything beyond what is in the plea agreement to get you to plead guilty to these 4 matters and these 2 files?
Absolutely not.
For example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir, I am.
Do you have any questions about what the court has told you, Mr. Doss?
No, sir.
Do you understand everything that the court has told you?
Yes, sir.
Now, in light of everything that the court has told you, do you still want to plead guilty to these 4 matters and these 2 files?
Yes, sir.
Then starting with file 21-6612-FH, drawing your attention back about 5 months ago to on or about March 5th of 2021. Were you in Hayes Township in Clare County, Michigan, Mr. Das? On that day and at that location, did you have some methamphetamine in your possession?
Unfortunately, yes, I did, sir.
When you had the methamphetamine in your possession on that day, did you know it was methamphetamine at the time you possessed it?
Yes, sir.
At the time you possessed the methamphetamine, was it with the intention that you would deliver that methamphetamine to someone other than yourself?
Actually, no, it was personal use.
Well, then how in the hell can I accept your plea of guilty to possession of methamphetamine with intent to deliver, Mr. Das?
I'm pleading guilty, sir.
Well, you've said I'm pleading guilty, but we have to establish if there's a factual basis for you to be guilty. And it's one thing to possess God knows how much methamphetamine with the intent that you're going to use it for your own twisted purposes and consume all of it, however much it might have been yourself. It's another thing to possess methamphetamine with the intent to deliver it or sell it or give it to someone else. Did you on that day possess this methamphetamine with the intent to deliver it to another person?
Yes, sir.
All right. And sir, drawing your, well, first with regard to count 1 in that file, Mr. Moore, are you satisfied there's a sufficient factual basis to accept the plea of guilty to that count?
Yes, sir.
Do you agree, Mr. Webb, as to count 1 in that file?
Yes, Your Honor.
Mr. Das, drawing your attention back to January 3rd of 2019 in the 55th Circuit Court in Clare County, Michigan, were you convicted of the felony crime of assault with a dangerous weapon?
Yes, sir.
Mr. Moore, are you satisfied that in that file there also is a sufficient factual basis to accept the guilty plea to being a habitual offender, second offense notice.
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Turning to file 21-6611-FH, Mr. Das, drawing your attention back to on or about January 31 of 2021. On that day and on that day, were you in Hayes Township in Clare County, Michigan?
Yes, sir.
On that day and at that location, were you driving a motor vehicle?
Yes, sir.
What kind of motor vehicle were you driving on that day, sir?
The black 98 Honda Civic.
And were you driving that automobile on East Cranberry Lake Road near Flats Road in Clare County,
Yes.
Michigan that day, sir?
Yes, sir.
And did that automobile you were driving have a stolen or false or counterfeit registration plate or license plate and registration tab on it, Mr. Doss?
Yes, sir.
And did you know that the license or registration plate and registration tab were stolen or false or counterfeit at the time you possessed them in Hayes
Yes, sir.
Township, Clare County,
Yes.
Michigan?
Yes, sir.
And sir, drawing your attention once again back to January 3rd of 2019 in the 55th Circuit Court for Clare County, Michigan, you convicted of the crime of assault with a dangerous weapon?
Yes, sir.
Mr. Moore, are you satisfied that there's a sufficient factual basis to accept these guilty pleas to all four of these matters in both of these two files?
Yes.
Do you agree, Mr. Webb?
Yes, Your Honor.
Mr. Moore, has the court complied with the court rule of the taking of these four guilty pleas in these two files?
Court has, Your Honor. Yes.
Do you agree, Mr. Webb?
Yes, Your Honor.
Very well, then, in these cases, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the pleas are accurate and have been understandingly, knowingly, and voluntarily made. The pleas are accepted and ordered entered on the records of the court. Sentencing in those two files will occur at 9 a.m. on Monday, October 4, 2021. On that same day, in file 20-6479-FH, will proceed to sentencing in that file as well. Bond is canceled in all three files, and the cases are adjourned to the date and time indicated. That will conclude our plea taking today, Mr. Das. But Agent Caitlin Brubaker, the probation department might have some additional instructions to give to you. Agent Brubaker.
Thank you, Your Honor. I will set up a Zoom PSI interview between Mr. Doss and Mr. Moore. I don't feel the need to do another PSI packet since he just completed one a few months ago. So we'll just do a brief Zoom interview regarding this new PSI.
Thank you, ma'am. That case, those three cases will be adjourned, then we'll be in recess in those three matters involving Mr. Das. Thank you, Mr. Das, and good luck to you, sir.
Thank you, sir.
We'll see you back here October 4th. Thank you, sir. Like the rest of your cases. Calling the cases of People versus Derek Philip Lugo, file numbers 17-5735-FH and file 18-5804. FH and file 21-6545-FH. Would counsel identify for the record, please?
Your Honor, Karen Tomczyk on behalf of Mr. Lugo.
Good afternoon, Your Honor. Mark Will on behalf.
Mr. Lugo, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, ma'am.
Could you tell us your name, sir?
Eric Philip Lugo.
Thank you, Mr. Lugo. You may lower your hand if you'd like. And
Thank you.
how did you want to proceed today, Ms. Tomczyk?
Well, Your Honor, I've been trying to touch base with probation to get an offer on this. This is Agent McConnell's case. He's not here today. So I mean, I hate to ask for maybe another status hearing. I'd like to try to resolve this case, but I kind of need everybody on the same page with this.
Sure. We'll schedule these three cases for a status conference at 10 a.m. on Monday, October 4, 2021. If you decide you want to address the cases before then, Ms. Tomczyk, feel free to contact the court. The bond status in all three cases will be continued, and the cases are adjourned at the date and time indicated.
Anybody here in person?
Not that I'm aware of.
There's a gentleman downstairs. What's your name, sir?
Nicholas Lloyd. Oh, I didn't realize you were gonna, I thought you were gonna be on Zoom.
I called, go get that away.
Calling the case of People versus Nicholas J. Lloyd. You may come forward if you'd like, Mr. Lloyd. File 21-6664-FH. Would counsel identify for the record, please?
Yeah, Karen Tomczyk on behalf of Mr. Lloyd.
If I could have a second, Your Honor.
Sure, thank you,
Undecided
Mr. Lloyd.
Canada people.
Oh, thank you, Ms. Ambrositis. Today is the date and time scheduled for a pretrial conference in this matter. Mr. Lloyd, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yeah.
Could you tell us your name, sir?
Nicholas J. Lloyd.
Are we proceeding by way of a pretrial conference or by way of a guilty plea, Ms. Tomczyk?
Plea, Your Honor.
And do you know to what count or counts that would be a plea?
Count one, possession of methamphetamine, Your Honor.
Thank you. Mr. Lloyd, do you understand, sir, that according to count one of the information, you are charged with the 10-year felony crime commonly known as possession of methamphetamine?
Yes, Your Honor.
Now, that crime is a felony and it carries a maximum penalty of 10 years in prison, and the minimum sentence would be discretionary with the court. Do you understand those things?
Yes, Your Honor.
It also carries a maximum fine of up to $15,000, but the minimum sentence is discretionary with the court. Do you understand all those things?
Yes, sir.
And finally, unless you are sentenced to more than 1 year in prison, then the court must suspend or revoke your driving privileges. Do you understand all of those things?
Yes, Your Honor.
Now, with regard to count one, possession of methamphetamine, you may make any of the following three pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to count one, possession of methamphetamine, sir?
Yes, Your Honor, I do.
Then answering to count one, possession of methamphetamine, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, sir.
The court also informs you that if your plea of guilty to count one is accepted, then that means you won't have a trial of any kind. The court would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Lloyd?
Yes, Your Honor.
And do you understand that by pleading guilty, that means you will be giving up each and every one of those rights?
Yes.
Now, sir, I'm going to ask your lawyer, Ms. Tomczyk, and the assistant prosecuting attorney, Mr. Webb, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement?
Your Honor, this is.
Your Honor, it's Michelle.
Thank
The
you,
offer
Michelle.
is for the defendant to plead guilty as charged. The people would recommend 7411 status if applicable. The defendant is to testify against Eric Whitacock truthfully when called upon to do so.
Thank you, Ms. Ambrositis. Ms. Tomczyk, is that your full and complete understanding of the plea agreement as well?
Oh, Your Honor, there is day-for-day credit for inpatient treatment successfully completed as well.
Is, with that clarification, is that your understanding of the plea agreement, Ms. Ambrositis?
Yes.
And yours as well, Ms. Tomczyk?
Yes, Your Honor.
Mr. Lloyd, did you hear what the prosecuting attorney and your lawyer said the plea agreement is?
Yes, Your Honor.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
I do.
Has anyone promised you anything beyond what is in the plea agreement to get you to be guilty to count one, possession of methamphetamine?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, Your Honor.
You understand everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still want to plead guilty to count one, possession of methamphetamine?
Yes, Your Honor.
And sir, drawing your attention back to on or about May 29 of 2021, were you in Freeman Township in Clare County, Michigan?
Yes, Your Honor.
On that day and at that location, did you have some methamphetamine in your possession?
I did.
When you had that methamphetamine in your possession, did you know that it was methamphetamine?
Yes.
Did you have any legal right or justification or mitigation permitting you to possess the methamphetamine?
No, Your Honor.
But you went ahead and did so anyway?
Yes, sir.
Are you satisfied, Ms. Tomczyk, that there's a sufficient factual basis to accept the plea of guilty to count one, possession of methamphetamine?
I am, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Ms. Tomczyk, has the court complied with the court rule of taking of the plea?
It has, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty to count one, possession of methamphetamine, is accepted and ordered entered on the records of the court. Sentencing will occur at 10 a.m. on October 4, 2021. The bond will be continued. The case will be adjourned at the date and time indicated. When you return on October 4, Mr. Lloyd, you could be put in prison for up to 10 years, or you could be put in county jail for up to a year, or something else might happen. One thing that will happen is you'll be ordered to pay some court-ordered money that will add up to close to $2,500. You now have another 7 weeks to take legal steps to raise that money and have it available to you on that day when you're sentenced on October 4th. That will conclude the plea taking. However, Agent Caitlin Brubaker from the probation department might have some additional instructions to give you. Do you have any such instructions, Agent Brubaker?
Yes, thank you, Your Honor. Mr. Lloyd, please step out into the hallway and wait for me to meet with you after court. I'm going to give you a packet of information.
Thank you, sir.
Thank you.
Good luck.
With that being said, Your Honor, is there a possibility of me getting the probation visionary closer to home?
That's something we'll have to address on October 4th. It's something you can discuss with Agent Brubaker if you'd like.
All right.
And Your Honor, I would be asking to be present for that as well.
Okay. Fine. Thank you, Ms. Tomczyk. Sure. Thank you.
Thank you, Your Honor.
Thank you, Mr. Lloyd. Good luck to you, sir.
Can the person with the phone number ending in 215 please identify yourself?
Jennifer Kuiper-Wiese, attorney for Mr. Murdoch.
Okay, and is your client appearing on Zoom this morning?
He's trying to get on to the Zoom phone call. We've had some issues this morning.
Okay, I have some people to identify, so I will place you back in the waiting room and bring you back in, okay?
Thank you.
The person with the phone number ending in 37, please identify yourself. Can the person with the Galaxy A10 phone, can you please identify yourself?
My name is Scott Nemitz.
Thank you. We're gonna place you back in the waiting room. Just hold tight, okay? Could you ask the jail to get Mr. Allenese, Joseph Allenese? Can you unmute your microphone, please? Person with the Moto Play 2021 phone.
It isn't unmuted.
Can you identify yourself, please?
Amy Edwards.
I'm sorry, can you repeat that?
Amy Lee Edwards.
Okay. Okay, Ms. Edwards, I'm gonna place you back in the waiting room for now, and I will bring you back in when it's time.
4 hours between the two, and then follow.
Can you identify yourself for the court, please?
Wendy Sue Kobrisky.
And please stay back in the waiting room for a moment. Can the person with the phone number ending in 537 please identify yourself?
Joseph Allenese.
One moment, Mr. Allenese. The person with the phone number ending in 537, can you please identify yourself?
Hello,
Yes, can you tell me what your name is, please?
Ronald Balser.
Thank you, Mr. Wilson. Okay, Judge, you can go forward with Mr. Allenese.
Calling the case of People versus Joseph Louise Allenese, file 20-6517-FH. Would counsel identify for the record, please?
Thank you, Your Honor. Karen Tomczyk on behalf of Mr. Alanis.
Joe Mazur, on behalf of people.
Mr. Alanis, thank you, ma'am. Mr. Alanis, would you please raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name?
Joseph Alanis.
You may lower your hand if you'd like, Mr. Alanis. How did you want to proceed, Ms. Tomczyk?
Your Honor, we received an offer from the prosecuting attorney in which Mr. Alanis will be pleading to counts 1, 3, and 4 with a BK agreement to no initial incarceration. Mr. Alanis wishes to accept that agreement offer.
Thank you. Mr. Alanis, sir, do you understand that according to count 1, you are charged with the crime of assaulting or resisting or obstructing a police officer?
Yes, sir.
That crime is a felony and it carries a maximum penalty of 2 years in prison and or a fine of up to $2,000. Do you understand those things?
Yes, sir.
Do you understand that according to count 3, you are charged with the crime commonly known as lying to a peace officer during a serious misdemeanor investigation?
Yes, sir.
That crime is a misdemeanor and it carries a maximum penalty of 93 days in the county jail and or a fine of up to $500. Do you understand those things?
Yes, sir.
Do you understand that according to count 4, you are charged with the crime of operating a motor vehicle while intoxicated, first offense?
Yes, sir.
That crime is a misdemeanor and it carries a maximum penalty of 93 days in the county jail and or a fine of $100 to $500. And the minimum sentence for count 1, count 3, and count 4 is discretionary with the court. Do you understand those things, sir?
Yes, sir.
With regard to count 1, count 3, and count 4, you may make any of the following 3 pleas to any of those counts. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to these 3 counts?
Yes, sir.
And answering to count 1, assaulting or resisting or obstructing a police officer, what is your plea?
Guilty.
Answering to count 3, lying to a peace officer during a serious misdemeanor investigation, what is your plea?
Guilty.
Answering to count 4, operating a motor vehicle while intoxicated, first offense, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentences will be?
Yes, sir.
The court also informs you that if your pleas of guilty are accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But on the other hand, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of those rights, Mr. Alanese?
Yes, sir.
Do you understand that by pleading guilty, that means you will be giving up each and every one of those rights?
Yes, sir.
Now, I'm going to ask your lawyer and the prosecuting attorney, Ms. Ambrositis, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Ms. Ambrositis, what is the plea agreement?
Your Honor, in return for the defendant's guilty plea to counts 1, 3, and 4, the people agree to dismiss the remainder upon sentencing and running the appropriate appeals period. There is an agreement pursuant to Briggs and Killebrew that there would be no initial incarceration. There is restitution for the blood draw of $35. There's $150 to law enforcement for a cost of their investigation, the statute, and actual cost of prosecution to statute.
Thank you, Ms. Ambrositis. Ms. Tomczyk, is that your full and complete understanding of the plea agreement as well?
It is, Your Honor. However, I would note that I did ask prosecuting attorney Ms. Schwartz if she had any objection to us requesting a personal recognizance bond based on the BK to no additional incarceration. She said she did not object to that. It is not part of the agreement. However, I will be asking for that after the court takes the plea.
Thank you, ma'am. With that clarification, is that your full and complete understanding of the plea agreement, Ms. Tomczyk?
Yes, Your Honor.
Mr. Alanese, did you hear what the elected prosecuting attorney, Ms. Ambrositis, and your lawyer, Ms. Tomczyk, said the plea agreement is, sir?
Yes, I did.
Did you understand the plea agreement?
Yes.
And do you agree with that plea agreement?
Yeah.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, they haven't.
So, for example, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No.
Has anyone threatened you or your family to get you to plead guilty?
No.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Freely and voluntarily.
Do you have any questions about what the court has told you?
No.
Do you understand everything that the court has told you?
Yes, I do.
In light of everything that the court has told you, do you still want to plead guilty?
Yes, I do.
Drawing your attention back to October 31 of 2020, were you in Clare County, Michigan?
Yes.
On that day and at that location, were you driving a motor vehicle on Main Street at or near Wright Street in Clare County, Michigan?
Yes, I was.
Immediately before driving that motor vehicle, had you drank some alcohol?
Yes.
And what kind of alcohol were you drinking and how much?
Quite a bit.
Okay, and what kind of quite a bit of this alcohol was it that you were drinking, Mr. Alanese?
It's in beer.
Okay, and were you stopped by Deputy Zachary Paisley of the Clare County Sheriff Department for a traffic violation on that day?
Yes.
And were you administered either a breath test or a blood test as part of that traffic stop or after the stop?
Yeah,
Did you have a bodily alcohol content of 0.08 grams or more at that time?
yes.
Do you know approximately what your bodily alcohol content was, sir?
No, I don't. It was above.
Your Honor, the lab report indicates that it was a 0.167.
Is that correct, Mr. Alanese?
Yes,
So at the point in time when you were operating the motor vehicle on October 31, 2020, you were intoxicated, is that correct?
yes, sir.
And Main Street where you were operating the motor vehicle is a public highway, correct?
Yes,
After Deputy Zachary Paisley stopped you, did he ask you some questions?
yes,
And was this related to the operating while intoxicated situation?
yes,
And did you lie to Deputy Zachary Paisley when he asked you those questions?
yes, I did.
And you knew you were lying at the time you did so, is that correct?
Yes, sir.
And these lies were false or misleading statements regarding the material facts relating to the operating while intoxicated serious misdemeanor investigation. Is that true, Mr. Alanese?
Yes, sir.
Now, at some point when you were interacting with Deputy Paisley on this date, did he place you under arrest?
Yes, he did.
And was he in uniform at that time?
Yes, sir.
You knew he was a police officer when he placed you under arrest, and when he stopped your motor vehicle, is that true?
Yes, sir.
And Deputy Paisley was acting in the lawful performance of his duties when he did those things?
Yes, sir.
Did you do anything towards Deputy Paisley to assault or batter or wound or resist or obstruct or oppose or endanger Deputy Paisley during the course of this investigation and this arrest?
I sure did. Yes.
What is it you did that falls into those categories, Mr. Alanese?
I guess I pulled away.
Okay, so he told you you were under arrest and he attempted to handcuff you, is that correct?
Yes.
And you struggled and pulled away from Deputy Alanese after he said those things and did those things?
Yes.
Are you satisfied, Ms. Tomczyk, that there's a sufficient factual basis to accept the pleas of guilty to count 1 and count 3 and count 4?
Yes, Your Honor.
Do you agree, Ms. Ambrositis?
Yes, Your Honor.
Ms. Tomczyk, has the court complied with the court rule in the taking of these 3 pleas?
Yes, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Very well, the court has not agreed upon the possible pleas or the possible sentences with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the pleas to counts 1, 3, and 4 have been made understandingly, knowingly, and voluntarily. Those 3 pleas of guilty are accepted and ordered entered on the records of the court. Sentencing will occur at 10 a.m. on Monday, October 4, 2021. Is there any issue as to bond, Ms. Tomczyk?
Your Honor, we would be asking pursuant to the agreement that is a BK, no initial incarceration. We would be asking for a personal or cognizant bond at this time, Your Honor.
Do you have any objection to the court granting that request, Ms. Township? I'm sorry, Ms. Ambrositis?
No, I don't, Your Honor.
Very well, then, the court will change the bond in this matter to a personal recognizance bond in the amount of $2,500. But personal recognizance, all the other terms and conditions of the bond will remain in effect. Mr. Alanis, when you come back here on October 4th, you could go to the state's prison for up to 5 years, or you could be put in the county jail for up to a year, or something else. I'm sorry. Actually, you could go to the state's prison for up to 2 years, or you could be put in the county jail for up to a year, or something else might happen. But one thing that will happen is you'll be ordered to pay about $2,500 in court-ordered money. You now have another 7 weeks to take legal steps to raise that money and have it available to you at the day of sentencing. That will conclude the plea-taking process today, except that Agent Katie Brubaker might have some additional instructions to give to you, Mr. Alanis. Do you have any such instructions, Ms. Brubaker?
Thank you, Your Honor. Mr. Alanis, what is the current mailing address for you?
2405 South Martin Luther King Junior Boulevard.
What city?
Lansing, Michigan.
Zip code?
4910.
48, I'm sorry.
4910.
All right. How about a phone number where we may be able to reach you at if you get out of jail today before I can get over there?
517-574-8123.
I'll try and drop off a packet of information to you today before you get released. However, if you don't get that packet, you need to contact our office upon your release, okay?
All right.
Thank you, Your Honor.
Thank you, Ms. Brubaker. We'll be in recess on that matter. Good luck to you, sir. Calling the case of People versus Wendy Sue Kabrisky, file 21-6669-FH. Would counsel identify for the record, please?
Members, I appearing on behalf of People.
Karen Township appearing on behalf of Ms. Kowarski.
Judge may approach.
Sure. Are you Wendy Sue Kabrisky?
Yes, sir, Your Honor.
Ms. Kabrisky, previously you appeared in court back on July 6, 2021. At that time, you pled guilty to the 5-year felony crime commonly known as domestic violence, third offense. You appear here today to be sentenced. The maximum penalty the court could impose is 5 years in prison. The minimum sentence is discretionary with the court, and the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 11 months, although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. You understand those things, Ms. Kabrisky?
Yes, sir.
And Ms. Tomczyk, have you gone over both of those reports with your client, Ms. Kabrisky?
Yes, Your Honor.
Is there anything of a factual nature in any of the reports you want to add to or explain or contradict?
No, Your Honor.
Do you have any challenges to the scoring of the offense variables or prior record variables or calculation as to the applicable sentencing guideline range being 0 to 11 months?
No, Your Honor.
Ms. Ambrositis, on behalf of the people, I would pose that same series of questions to you.
Your Honor, we've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. I reviewed the prior record variable scoring and the offense variable scoring and find that to be accurate as well.
Thank you, ma'am. Ms. Kabrisky, is there anything you want to say on your own behalf before the court passes sentence, miss?
Yes, Your Honor. I'd like to ask you for your permission to get my personal belongings.
Thank you, ma'am. Is there anything else you want to say, ma'am, or not?
No.
And on behalf of your client, Ms. Tomchik?
Yes, Your Honors, we often see with these situations, this is an unfortunate situation. I think what Ms. Kubrisky is asking for, put more in legal terms, Your Honor, would be a one-time officer assist to the property so she can get her personal belongings. We ask that, Judge, you follow the agreement, sentence was to a period of probation in this case. And I don't think this is somebody that you will see again.
Thank you, ma'am. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response. And on behalf of the people, Ms. Ambrositis?
We ask that you follow the recommendations in the plea agreement in this matter.
Thank you, ma'am. Ms. Kabrisky, in order to punish you for what you've done and to punish you for what you've done and to give you the opportunity to rehabilitate yourself and to deter you and others from committing crimes in the future, it's the sentence of the court. You'll be placed on probation for a period of 2 years. In addition to all the statutory terms of probation, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to drug and alcohol testing on demand, and you must successfully complete any substance abuse treatment program or any alternatives to violence treatment program to which you are referred by the probation agent, and you must give up any confidentiality right you have in any such program so that the court may monitor your progress. You must pay a supervision fee of $30 per month, rising to $60 per month for any time period during which you are on electronic supervision. You must not have any contact with anyone whom you know to have a felony record. You must seek and maintain full-time employment, and you must submit to a search of your person and property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must not have any contact with Ronald Davenport or be within 500 feet of his residence, school, or place of employment. You must not use or possess any weapons or copies of weapons. You must comply with DNA testing and pay a $60 fee for that purpose, and you must pay $68 in state costs and a crime victims assessment of $130, court costs of $500 and a fine of $500, and court-appointed attorney fees of, do you have an estimate, Ms. Township?
$360, Your Honor.
$360. How much of that $1,800 or so do you have? Actually, it would actually be how much of that $2,000 or so do you have available today to apply towards your court-ordered monies, Ms. Kabrisky?
I can bring the 2,000 today.
All right, then you must pay all of your court-ordered monies by 3 p.m. tomorrow. Finally, you must serve 22 days in the Clare County Jail, but you will receive credit for 22 days already served. Does that comply with your understanding of the Briggs Killebrew sentence cap, Ms. Township?
Yes, Your Honor.
That will be the sentence of the court. It's my duty to inform you, ma'am, that you are entitled to appellate review of your conviction and sentence. And if you're financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Bond is canceled. Any bond posted in the defendant's own name will be applied towards court-ordered money. The court will authorize a one-time police officer monitored visit for Ms. Kabrisky to pick up her belongings. Apparently, this would be at the house of the victim, Ronald Davenport. And if the
It is about me, Scotty. I'm the one that's doing what I'm.
Who are you, sir? Okay, thank you. I'm sorry to overreact. Very well, that will be the sentence of the court. Good luck to you, Mr. Kabrisky.
Thank you, Your Honor.
You're welcome, ma'am. Good luck to you.
Your Honor, if I may address Ms. Kobrisky for one moment.
Sure.
Thank you. Ms. Kobrisky, you need to contact Agent Ween by 4 p.m. today. He's your probation agent. Do you still have the same phone number? I could just text you his number.
Yes, I do have the same number.
I'll send it to you right now. Thank you. Thank you, Your Honor.
Thank you.
Thank you, Agent Brubaker, and good luck to you, Ms. Kabrisky. We'll be in recess on that matter. Calling the case of People versus Ronald James Balser Jr., file 21-6649-FH. Would counsel identify for the record, please?
Thank you, Your Honor. Karen Tomczyk on behalf of Mr. Belser. Do we have Mr. Woodbeck?
I'm here.
Mr. Belser, would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name, sir?
Excuse me?
Could you tell us your name, sir?
Oh, Ronald Balser.
You may lower your hand if you'd like, Mr. Balser. Today is the date and time scheduled for a status conference in this case. How did you want to proceed, Ms. Tomczyk?
Your Honor, I've discussed the plea offer with Mr. Belser. At this point in time, he does not wish to avail himself of that offer. We'd be asked that this matter be set on the trial docket.
All right, we'll schedule a jury trial on the 10-year felony crime of possession of methamphetamine. The case will proceed to trial. Thank you for being here, Mr. Balser.
Thank you.
You're welcome, sir.
Brent, can you set the jail at Joshua Carlton?
Correctional court security.
Sure. Calling the cases of People versus Haley Wright, file 20-6414 FH and file 20-6502 FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Wright.
Ms. Wright, would you please raise your right hand to be sworn, miss?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? I do.
Could you tell us your name, ma'am?
Haley Wright.
Today is the date and time scheduled for a hearing as to why the defendant should not be held in criminal contempt of court for allegedly failing to appear here in court previously as ordered. Mr. Rowe, are we proceeding by way of a plea on the underlying matters or in some other way?
Your Honor, we might, if I may ask Mr. Webb a question.
Sure.
Mr. Webb, Ms. Wright said she'd be willing to make a plea if she could get an agreement of time served for initial incarceration.
How much time is that?
Ms. Wright, how much time did you spend in the Clark County Jail?
I didn't spend any in the Clark County Jail. It was the plea offer I was given that you told me about was it would run concurrent with Isabella County, and I spent almost 7 months in Isabella County.
When were you in the Isabella County Jail, miss?
I just got out July 3rd.
Okay, and so the 7 months you spent in jail was after June of 2020?
I was in there in June. Oh wait, no, sorry, 2020. No, it was February of 2021 to July 2021.
Okay, thank you. Do you have any interest in making that offer, Mr. Webb, or not?
I don't think I am today, but I'm willing to discuss this further with Mr. Rowe.
Okay. With that in mind, then you want this matter scheduled for a plea, then Mr. Rowe, on October 4 of 2021.
Your Honor, it might be better for a status conference since I don't think we have a meeting of the minds yet. Unless Ms. Wright would like to accept the current offer, which has an agreement to 6 months of jail.
All right. We'll schedule the case for a status conference to occur at 10:20 a.m. on Monday, October 4, 2021. In each one of these two files, the bond status is continued. The cases are adjourned at the date and time set. But Ms. Wright, make sure you follow all the conditions of your bond, and make sure you stay in touch with your lawyer, Mr. Rowe.
Okay, I'm currently doing, drug tests at Compass for my probation officer for Isabel County. So I was just wondering, would you guys like me to click on into it?
What are you doing for Compass, miss?
I'm doing Compass drug testing for my probation officer in Isabel County.
Okay, if you would have that agent notify the Clare County Clerk's Office, I would appreciate it. Thank you, ma'am, and we'll make that a condition of your bond as well.
Okay, thank you.
Thank you, ma'am.
Looks like the jail might be having technical issues there. I don't know if
Could you have Mr. Carlton?
Do you want it brought over in person, Judge?
Yeah, apparently they're having some difficulties. And is calling the case of People versus Amy Lee Edwards, file 21-6708-FH with counsel identified for the record, please.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Edwards.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Ms. Edwards, would you raise your right hand and be sworn, ma'am?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name?
Amy Lee Edwards.
Thank you, Ms. Edwards. You may be seated if you'd like. How did you want to proceed regarding this arraignment, Mr. Rowe?
Your Honor, Ms. Edwards waives the reading of charges and she pleads not guilty.
Very well, pleas of not guilty will be entered on behalf of the defendant as to all counts in the case. The case will proceed to a pretrial conference. Thank you for being here, Ms. Edwards. The bond status will be continued as well.
Thank you, Your Honor. Am I allowed to address you about my conviction?
About your what, ma'am?
I have no contact order between me and my children, and my the judge from last week said that you would be the best one to be able to make that decision for me to be able to see my children supervised.
All right. Is that something you want to address today or not, Mr. Rowe?
Ms. Edwards, pardon me, Your Honor, Ms. Edwards, did you get a service plan from the family court?
I have paperwork that has stating that I can see the children.
Okay, could you send that to my office, please?
I sure will. Yep.
Thank you. Your Honor, I know Ms. Edwards is desiring greatly to go and ask the court to lift the no contact order with her children on the argument that they're being supervised by in the process of her meeting them because it's part of a case in the family division, the circuit court. But I don't think I'm prepared enough to go ahead without looking at those service agreements or service orders that are supposed to come from that court.
Judge,
All right.
I would concur with that. This is kind of a complicated situation as far as having contact with her kids and how that relates to these criminal charges. So I'd ask that a written motion be filed by the defendant to get a chance to
Thank you,
respond.
Thank you, Mr. Webb. And if the parties reach an agreement, then that might resolve it. But if not, in any event, please file a written motion if you deem that to be appropriate, Mr. Rowe. In the meantime, the case will proceed to a pretrial conference or other disposition. Thank you for being here, Ms. Edwards.
Thank you.
We do have the, prison one down for journalism that doesn't really have any. Like his files. Jonah.
Okay. He's in prison, so.
Yes, we have a reform, they're logged on.
Okay, calling the case of People versus Jonah Reed Vaughn, file 21-6671-FH, and also file 21-6577-FH. Would counsel identify for the record, please?
Members, I have People.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Vaughn.
Today was the date and time scheduled for a pretrial conference in these files. How did you want to proceed in that regard, Mr. Rowe?
Your Honor, is Mr. Vaughn present?
Mr. Vaughn is not presently present. He's not present. Apparently, the Department of Corrections had contacted us, but he is not present.
Your Honor, I did have, pardon me for interrupting.
Go ahead, sir.
I did have a conversation with him earlier this morning. He was wanting to enter a plea on the newer file, which I believe is 6671. 21-6671FH. And because of entering a plea on that, he's going to ask for an adjournment in the other file, which is scheduled for sentencing, so that he could be sentenced on both cases at the same time.
All right, we'll schedule the case for entry of a plea in file 21-6671-FH, and we'll adjourn any sentencing scheduled in the other file, and we'll try to coordinate the sentencing matters. That case will be adjourned without date. Thank you, Mr. Rowe. Calling the cases of People versus Joshua L. William Carlton, file numbers 21-6565-FH and 18-5964-FH and 20-6308-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb, on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk appearing on behalf of Mr. Carlton.
Mr. Carlton, would you raise your right hand and be sworn, sir?
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Could you tell us your name?
Joshua L. William Carlton.
Mr. Carlton, in file 21-6565-FH, you appeared here today to show cause why you should not be held in criminal contempt of court and why your bond should not be revoked and forfeited for your alleged failure to appear in court previously. In the other two files, you appeared here today for a status conference. How does your client want to proceed today, Ms. Tomczyk?
Well, Your Honor, in speaking with my client, he does wish to accept the offer, the prosecutor's offer, in file number 6565, Your Honor. My suggestion would be is that we enter a plea in that case, and then we set this matter for a plea on the probation violations along with the sentencing on this new case.
Any objection to that procedure, Ms., or Mr. Webb?
No, Your Honor.
Very well. Mr. Carlton, I apologize, sir. Did you swear to tell the truth?
Yes, sir.
Thank you. Mr. Carlton, in file 21-6565-FH, what counter counts would he be pleading to, Ms. Township?
Your Honor, you're pleading to the conspiracy to commit furnishing contraband to a jail prisoner, and there is a sentencing recommendation of 6 months.
And would the habitual offender second offense notice be dismissed along the way or not?
I'm shaking my head. No. I don't believe so.
I'm looking at the probable cause summary. I don't think I have anything other than that, Your Honor. I don't see that I have a pretrial offer that has anything different.
Was it, I'm sorry, Your Honor. Karen, was it he discharged? That's what I have. But I don't have that PCC in front of me.
No, I just have a plea to count 1, conspiracy to commit furnishing contraband to prisoners. Recommendation of 6 months in the Clare County Jail.
Okay, then I'll agree to dismiss the second.
All right. Mr. Carlton, sir, do you understand that according to count 1, you're charged with the crime commonly known as conspiracy to furnish contraband to a prisoner in a jail?
Yes, sir.
That crime is a felony and it carries a maximum penalty of 5 years in prison and or a fine of up to $11,000, and the minimum sentence would be discretionary with the court. You understand those things?
Yes, sir.
Now, with regard to count 1, you may make any of the following 3 pleas. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 1, conspiracy to furnish contraband to a prisoner in a jail?
Yes, sir.
Then answering to count 1, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, sir.
The court also informs you that if your plea of guilty, well, first, what is your plea?
Guilty.
The court also informs you, sir, that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial, and if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of those rights, sir?
Yes, sir.
And do you understand that by pleading guilty, that means you be giving up each and every one of those rights?
Yes, sir.
Now, I'm going to ask your lawyer and the assistant prosecuting attorney, Mr. Webb, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement?
Your Honor, it's my understanding the defendant will be pleading guilty to count one, the conspiracy to furnish contraband to a jail prisoner. I'll dismiss the hab second at sentencing. I recommend 6 months in the Clare County Jail. And after speaking with the probation agent who is familiar with them, they are recommending no probation.
Okay, but that's not part of the plea agreement, or is it?
It is, Your Honor.
All right. Ms. Tomczyk, is that your full and complete understanding of the plea agreement?
Well, Your Honor, I would clarify too that count 2 would be being dismissed as well. I know that there's been discussions that probation would be recommending no probation, and I do know, and I've spoken with Mr. Carlton about what the likely recommendation would be on a probation violation. Based on entering a plea off of the PCC form that the prosecutor has made, I would say that the no probation is not part of the plea agreement. But in noting too that if it is simply a recommendation, Your Honor, the judge is not held to it, and nor can anyone, I guess, withdraw the plea on either side if Your Honor does not follow no probation.
Is that with that clarification, is that your full and complete understanding of the plea agreement, Ms. Tomczyk?
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Now, Mr. Carlton, did you hear what your lawyer and the prosecutor said the plea agreement is?
Yes, sir.
Did you understand the plea agreement?
Yes, sir.
And do you agree with it?
Yes, sir.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count 1?
No, sir.
So for example, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or threatened your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
Yes, sir.
And in light of everything that the court has told you, do you still want to plead guilty to count 1?
Yes, sir.
Then, sir, drawing your attention back to on or about January 8th of 2021, were you in Hayes Township in Clare County, Michigan?
Yes, sir.
On that day and at that location, did you unlawfully conspire with Jessica Carlton and Jordan Carlton and or other unknown persons to commit the crime of furnishing Suboxone, a controlled substance, to a prisoner in the Clare County Jail?
Yes, sir.
Are you satisfied, Ms. Tomczyk, that there's a sufficient factual basis for the plea of guilty to count 1?
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Ms. Tomczyk, has the court complied with the court rule in the taking of the plea?
It has, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Very well. In this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty is accepted and ordered entered on the records of the court. Sentencing will occur at 10 a.m. on Monday, October 4, 2021. Bond is canceled and the case will be adjourned to the date and time indicated On that same date and time, the court will conduct a status conference on possible plea and possible sentencing in files 18-5964-FH and file 20-6308-FH. That will conclude the plea taking process in this file, Mr. Carlton. However, probation agent Brubaker might have some additional instructions to give to you, and her department might well want to prepare an updated probation violation matter report for October 4th in the 2020 and 2018 file as well. Agent Brubaker, do you have any instructions to give to Mr. Carlton?
Yes, thank you, Your Honor. Mr. Carlton, I'll be dropping off a PSI packet to the jail today. Make sure you fill it out completely, and we'll schedule an interview with that packet once it's completed, okay?
Okay, man.
Thank you, Your Honor.
Agent. Thank you, ma'am. Very well, bond is canceled and the cases are adjourned to the date and time indicated.
Mr. Breaker, I would ask for notice of that interview.
No problem, Karen. I'll get that out to you.
Thank you. We'll take a short break.
All right.
Please be seated. Good afternoon. You may be seated. Calling the case of People versus William Scott Nemitz, or Nemitz, file 20-6411-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Tara Hovey on behalf of Mr. Nemitz.
Mr. Nemitz, would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name?
William Scott Nemitz.
Mr. Nemitz, previously, there had been a motion to adjourn the trial. The court granted the motion to adjourn the trial. At that time, there was a request to remove the no contact order. And the court, this was back, I believe, on August 2nd. The court denied the request to remove the no contact order and scheduled a hearing on the motion to be held September 7 at 11 a.m. This matter is not on the docket for today, but the court has been informed that the defendant, the defense attorney, the alleged victim, who is the protectee of the protective order, and the prosecutor all are available to address the motion to lift the no contact order. How would you like to proceed in that regard, Ms. Hovey?
Your Honor, if I may.
Yes, Mr. Webb.
If the parties will allow, I'd like to question Ms. Nemitz, and depending upon her answers, I would probably move to dismiss this case.
Okay. Any objection to that, Ms. Hovey?
Absolutely not.
Okay, go ahead, Mr.
Webb?
Yes, Mr. Webb.
Thank you, Your Honor.
But Ms. Nemitz, I'm sorry, Ms. Nemitz, you are present as well, Miss? Is that true?
Yes.
Would you raise your right hand to be sworn, Miss?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name, Miss?
Crystal Nicole Nemitz.
You may be seated if you'd like. I'll direct your attention to Assistant Prosecuting Attorney Mark Webb. He has some questions to ask of you.
Okay, sir, thank you.
Thank you. You may proceed if you'd like, Mr. Webb.
Thank you, Your Honor. Mrs. Nimitz, can you hear me?
Yes, sir, I can.
And you're Crystal Nimitz?
Yes, sir, I am.
And you're married to William Nimitz?
Yes, sir, I am.
And how long have you been married?
We're going on 4 or 5 years of marriage and 8 years of a relationship.
Okay. And you're the alleged victim in this case, correct?
Alleged, yes.
And this case started last year in June sometime?
Yeah, it's been like 15 months.
Have you had contact with your husband during that time?
No, we had one time happened to be in the same store together, but it was found that we didn't know each other was in the store. But other than that, no.
Okay, you haven't been together in your home or
no
somewhere else. And it's my understanding that you spoke with the prosecutor's office sometime, if I recall, it wasn't to me, but to somebody in our office about wanting to have this case dismissed.
Yes, sir.
Do you recall who you spoke with?
I'm thinking it was either one of the secretaries or it was the assistant prosecutor. I know it wasn't Michelle because I've only spoke to her the one time in court.
Okay, let me ask you this: could it have been our victim's
Or,
advocate?
yeah, Stacy Newman when she was.
Okay. And did you tell her you wanted to, you didn't want to proceed with this case?
Yes, sir, I did.
And in fact, I think you told the police that your husband had not assaulted you?
Yes, sir, I did tell the police that.
And do you understand that the police report indicates that a neighbor saw what happened and called the police?
I understand that's what's being said, yes.
Okay. And is it your wish today not to pursue this case?
Absolutely.
And I want you to understand that there is a no contact order that's been in place since this case started, correct?
Yes, sir.
And that no contact order the purpose of that was to protect you from your husband.
I understand the intentions of it. Yes,
okay.
sir.
Okay. And if I move to dismiss this case, that bond condition and any other bond conditions that are in place will not exist anymore. You understand that?
Yes, sir. And that's what I'm hopeful for.
All right. And do you also understand that if I move to dismiss this case based on what you're telling us in the court, that this case will be over with and there'll be no trial or any other resolution where
Yes,
a
sir.
conviction may enter. You understand that?
Yes, sir, I do.
And I want to make sure, do you feel comfortable and feel safe if I do move to dismiss this case?
Yes, I do. I haven't felt safe since my husband hasn't been here.
All right, you're not going to be afraid of him if he's allowed to come back.
No, sir. No, sir. It's kind of the exact opposite. He was fleeing from me. I don't understand how we got this far, but
okay. I don't believe I have any more questions, Your Honor.
Ms. Nemitz, are you asking the prosecuting attorney to dismiss the charge?
yes, sir, I am.
And you understand that if the charge is dismissed, in all likelihood, it never would be brought again against Mr. Nemitz for this incident that allegedly happened back in June 1 of 2020?
Yes, sir, I do.
All right. Now, if in fact the case is dismissed, and if in fact at some point in the future Mr. Nemitz, you feel threatened by Mr. Nemitz or a victim of an assault, are you going to feel like, well, I can't call the police because I'm going to look like a damn fool because I got
No.
the last case dismissed? Or will you have enough intestinal fortitude to at least try to protect yourself and to contact the authorities?
First and foremost, sir, mine and my child's safety is most important.
Okay, thank you, ma'am. And knowing all of these things, do you still want the case to be dismissed?
Yes, sir, I do.
And that's what you're asking the prosecutor to do, is to ask the court to dismiss it?
Yes, sir, I am.
Okay, thank you, ma'am. Do you have any other questions, Mr. Nemeth? I'm sorry, Mr. Webb.
No, thank you. No, thank you, Your Honor.
And Ms. Hovey, do you have any questions you wanted to ask?
Not
Ms.
in regard to any dismissal, Your Honor.
Okay, thank you, ma'am. Very well. Is there anything else you wanted to address today, Mr. Webb
No, Your Honor.
or Ms. Hovey?
No, Your Honor, and unless the prosecutor does not advance the motion he indicated, I want to discuss bond, but other than that, no.
How would you like to proceed today, Mr. Webb? Do you want me just to address the bond issue at this time?
No, I would move to dismiss this without prejudice.
Very well. Any objection, Ms. Hovey?
No, Your Honor.
Very well. The case will be dismissed without prejudice. Thank you all for being here.
Thank you, Your Honor.
Thank you, Ms. Hovey. Thank you, Mr. Webb. Thank you, Ms. Nemitz and Mr. Nemitz.
Am I allowed to go?
Let's do
Oh, good.
but you're not sure. His lawyer.
Yeah, I'm bringing her in right now. They said he's called our office and he keeps trying to call him and he can't get in. So,
Thank you. That's what they're telling me. What he is doing.
he has contacted our office and said he keeps trying to call him and won't let him in.
Calling the case of People versus Joshua John Murdoch, file 21-6593-FH. Would counsel identify for the record, please?
Members, I speak on behalf of People.
Jennifer Kaiperwisi on behalf of Mr. Murdoch.
Does Mr. Murdoch appear? The
Mr.
record
Murdoch
should indicate. The record should indicate no response. The record should indicate Mr. Murdoch was ordered to be here today, going on 4 hours ago at 10:40 a.m. It's now 2:17 a.m. by 2:17 p.m. by the court's clock. Mr. Murdoch still has failed to appear. However, allegedly, Mr. Murdoch has tried to contact the clerk's office and is having difficulty being admitted to the Zoom proceeding. How did you want to proceed today, Ms. Cooper Weiss?
Well, Your Honor, I am in incredible embarrassment right now. I am incredibly sorry. I filed an adjournment the first time around because we did not have a pre-sentence investigation report. And because my client did not show up for that date accidentally, my client ended up doing his PSI. I checked in with him after that. I don't recall ever seeing a notice for sentencing for today, and otherwise I would have been there in person. For some reason, Your Honor, I blocked out September 7th as a travel day to Clare County to appear for his sentencing. And sorry.
I'm sorry, ma'am. I apologize for cutting you off.
No, it's my fault. I just want the court to know that this is entirely my fault, if anyone's, not Mr. Murdoch. I have been on the phone with him since 11:45 this morning, talking to him, talking to Annette from Michelle Ambrositis' office, who also thought this was on September 7th because MDOC told her that. I don't know where the confusion is, but it's probably all my fault. And I want the court to know that I am humbly asking for forgiveness. It is not my client's fault. He has appeared, he is trying, he's talked to me all day trying to get on the Zoom. I've been kicked off it twice. I don't know if it's a service issue or what the issue is, but I have been, waiting here with him to talk to the court and to plead our case. And I'm incredibly sorry.
Oh, that's quite all right, ma'am. We're the ones who are keeping you and the prosecutor waiting as well. Why don't we adjourn the sentencing then until 11 a.m. on Tuesday, September 7th, 2021.
I will be there in person, Your Honor.
Do you have any objection to that, Ms. Ambrositis?
I have no objection, Your Honor, but I would point out for the record, I don't think that this is Ms. Weese's fault at all. We didn't get any notice. The last hearing that I have in my system was from the last hearing we had scheduled that we adjourned. So we didn't get any notice from the court for today's date or for September 7th. The only reason we knew it was on the docket is because we looked at the docket on Friday and saw that it was on there. I can tell you that we called the victim. She appeared and her mother appeared. Her mother was very upset that this wasn't going again today and that she was upset that it was adjourned before. And so that I do ask that if we are going to put it on for 9/7, then it does go on 9/7 as scheduled at 10:40 in the morning. Thank you.
Thank you, ma'am. And I had said 11, I believe. Let's set it for 10:40 a.m. on Tuesday, September 7th. But let's do the sentencing in person. And I would ask that the defendant and the defense attorney appear in person on that day. Thank you, ma'am.
Thank you.
And I apologize for any miscommunication.
No, I'm very sorry. Thank you, Ms. Ambrositis, for that clarification. I thought I had lost my mind. Thank you.
Thank you, ma'am.
Which I might have. Thank you.
You're welcome. Thanks again.
Mr. Are we still in a breakout? Mr. Jones, do you want to go ahead with Mr. Close?
Sure.
Bring the curtain. He's coming.
Calling the case of William E. Kuhn and Marion M. Kuhn versus Anthony A. Voisin and his heirs, successors, and assigns, file 2021-900-238-CH. Would counsel identify for the record, please?
Yes, good afternoon, Your Honor. J.J. Klaus representing William and Marion Kuhn, the plaintiff.
Good afternoon, Mr. Klaus. Does anyone appear in this matter for the defendants? The record should indicate.
Like Mr. Boyce is on today. I didn't expect him today, but that's fine. I appreciate him being here.
Thank you. Does anyone appear for Mr. Voisin or his heirs or successors or assigns? The record should indicate no response. This case was scheduled to be heard at 2 p.m. And that was on the, actually it was scheduled to be heard at 1:30 p.m. on the plaintiff's motion for quiet title. How would you like to proceed in that regard, Mr. Klaus?
Your Honor, we've presented to the court an order to be entered in this matter. That order, Mr. Voisin has approved that order to be entered. Essentially, we ended up defaulting him. There were no defensive pleadings. I will say that he's cooperating. This is a situation where we need to get a title to a manufactured home. Mr. Voisin had detached the home but no title was issued after that point. So we're asking the, Mr. Boyce sold this manufactured home to Mr. Kuhn, and we never had a title. We couldn't get one from the state. And this was our alternative, was to ask this court to quiet title. I think all parties, including the defendant, are in agreement with entry of the order.
All right, it does appear to the court that it is appropriate to grant the hearing for entry of default and the entry of a default judgment in order to quiet title. The plaintiff's attorney, Mr. Klaus, has submitted to the court a proposed order to quiet title. Is that what you would like me to sign, Mr. Klaus?
Yes, Your Honor, and I believe that that order should have Mr. Boyce's signature dated July 13th, 2021, that he's approved the order as entered, or as proposed.
I'm sorry, Mr. Klaus, you are correct. Thank you for bringing that to the court's attention. The court has reviewed a proposed order to quiet title consisting of 2 pages and bearing on the second page at the bottom, the purported signature of Anthony A. Voisin, the defendant in this case. The court has signed the proposed order consisting of 2 pages, and I will file that order with the clerk of the court and ask her to provide a true copy to you, Mr. Klaus, and to any other parties in the case as well. Thank you, sir.
Thank you, Your Honor.
Is there anything else you wanted to address, Mr. Klaus?
No, not at this time.
Thank you, sir. Then we'll be in recess. The record should reflect it is 2:25 p.m. by the court's clock. Mr. Voisin has failed to appear, plus Mr. Voisin signed the proposed order in any event. Thank you all. We'll be in recess on that matter.
Thank you, Your Honor.
Mr. Rowe, are you all set?
Well, I need to ask Mrs. Ambrositis a question, I guess, about Jones.
I responded to your email, Austin.
Mr. Jones is interested in accepting your plea bargain, but I don't think you can substantiate count 1. Can you do it as a no contest plea?
The offer was no contest or guilty to all 3 counts as charged.
So if he's to accept it, at least to count 1, that needs to be a no contest plea.
That's fine.
So, Your Honor, I think Mr. Jones would plead plea according to the plea bargain today, but Mr. Jones' plea would be no contest to count 1 and then guilty to counts 2 and 3.
Okay. Do we have a police report or a something on which we can accept a no contest plea to count 1, possession of methamphetamine with intent to deliver?
Judge, I have printed the unsigned probable cause affidavit to the law library printer, and that can be used.
Thank you. Thanks, Ms. Ambrositis. Mr. Jones, would you please raise your right hand to be sworn, sir?
Mr. Jones, I'll need you to unmute the microphone, please. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name, sir?
Jason A. Jones.
Mr. Jones, sir, do you understand that according to count 1, you are charged with the crime commonly known as possession of methamphetamine with intent to deliver?
Yes.
That crime is a felony, and it carries a maximum penalty of 20 years in prison and/or a fine of up to $25,000. You understand those things?
Yes,
The minimum sentence would be discretionary with the court, although unless the court sentenced you to more than 1 year in prison, then the court must impose driver license sanctions according to Michigan Compiled Law 333.7408A. Do you understand that?
yes,
Now, in count 2, you are charged with possession of methamphetamine. Do you understand that, sir?
yes, I do.
That crime is a felony also, but it carries a maximum penalty of 10 years in prison and/or a fine of up to $15,000. Do you understand those things?
Yes, Your Honor.
Now, the minimum sentence would be discretionary with the court, although, once again, unless the court sentences you to more than 1 year in prison, the court must suspend or revoke your driver's license pursuant to Michigan Compiled Law 333.7408A. Do you understand that as well, sir?
Yes,
Finally, in count 3, you are charged with the crime commonly known as maintaining a drug house. That crime is what we call a high court misdemeanor, and it carries a maximum penalty of 2 years in prison and/or a fine of up to $25,000. The minimum sentence would be discretionary with the court, although, once again, unless the court sentenced you to more than 1 year in prison, the court must suspend or revoke your driver's license pursuant to Michigan Compiled Law 333.7408A. Do you understand all of these things, Mr. Jones?
yes, I do, Your Honor.
Now, with regard to count 1, possession of methamphetamine with intent to deliver, you may make any of the following 4 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. Third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. And fourth and finally, you may plead no contest, which means that you do not contest the prosecutor's proofs, and it amounts to a plea of guilty. Do you understand the 4 possible pleas you may make to count 1, possession of methamphetamine with intent to deliver, sir?
Yes, I understand.
Then answering to count 1, what is your plea, Mr. Jones?
Mr. Jones, you'll plead no contest. So you need to say that, sir.
No, no contest, Your Honor.
Thank you, sir. Now, Mr. Jones, regarding count 2, possession of methamphetamine, and regarding count 3, maintaining a drug house, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 2 and to count 3, Mr. Jones?
Yes, I do, Your Honor.
Then answering to count 2, possession of methamphetamine, what is your plea?
Guilty.
Answering to count 3, maintaining a drug house, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentences will be?
Yes, Your Honor.
The court also informs you that if your pleas of no contest and guilty are accepted, that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge without a jury, if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial, and if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of those rights, sir?
Yes, Your Honor.
And do you understand that by pleading no contest and guilty, that means you'll be giving up each and every one of those rights?
Yes, Your Honor.
Now, I'm going to ask your lawyer, Mr. Rowe, and the elected prosecuting attorney for Clare County, Ms. Michelle Ambrositis, to tell us what the plea agreement is. And I want you to listen to both of them very carefully. Ms. Ambrositis, what is the plea agreement?
In return for the defendant's no contest plea to count 1 and guilty to the remaining counts in the felony information, the people would agree, pursuant to Bergen Killenberg, the defendant would receive sentencing at the bottom end of the MDOC determined guidelines. Restitution is to be determined, and forfeiture of the contraband seized will occur.
Mr. Rowe, is that your full and complete understanding of the plea agreement as well, sir?
It is, Your Honor.
Mr. Jones, did you hear what the prosecuting attorney and your lawyer said the plea agreement is?
Yes, I did, Your Honor.
Did you understand the plea agreement?
Yes.
And do you agree with that plea agreement, sir?
Yes, I do.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead no contest and guilty?
No, Your Honor.
So, for example, has anyone promised you that if you plead no contest and guilty, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or threatened your family to get you to plead no contest and guilty?
No, Your Honor.
Is it your own personal choice to plead no contest and guilty? And are you doing so freely and voluntarily?
Yes, I am.
Do you have any questions about what the court has told you, sir?
No, I don't.
Do you understand everything that the court has told you?
Yes, I do.
In light of everything that the court has told you, do you still want to plead no contest and guilty?
Yes, Your Honor.
Very well, then, with regard to count 2 and count 3, drawing your attention back to April 12 of 2021, were you in Lincoln Township in Clare County, Michigan?
Yes, Your Honor.
On that day and at that location, did you have some methamphetamine in your possession?
Yes, I did, Your Honor.
Did the substance that you had in your possession at that time, did you know that it was methamphetamine at the time you possessed it?
Yes, I did, Your Honor.
Did you have any legal right or justification or mitigation allowing you to possess the methamphetamine?
No, Your Honor.
On that same day and at that same location of April 12, 2021 in Lincoln Township, Clare County, Michigan, were you in possession of a house?
Yes, Your Honor.
And did you use that house? Did you maintain that house? And during the time you were maintaining it on April 12, did persons come to that house for the purpose of buying or using controlled substances? And did you also keep controlled substances in that house at that time illegally?
Yes, Your Honor.
Are you satisfied, Mr. Rowe, that there's a sufficient factual basis to accept the pleas of guilty to count 2, possession of methamphetamine, and count 3, maintaining a drug house?
I am, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Do you, Mr. Rowe, has the court complied with the court rule in the taking of those 2 pleas?
It has, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
With regard to count 1, what is it that that parties would like the court to review to see if there's a sufficient factual basis to accept the no contest plea? Is it the unsworn affidavit in support of the complaint or the warrant?
Yes.
Yes, Your Honor.
Thank you, Mr. Rowe. You would like me to review that as well, sir?
Yes, sir.
Very well, then the court has reviewed the unsworn affidavit and finds that it establishes date being on or about April 12 of 2021, venue being Lincoln Township in Clare County, Michigan, identification of the defendant, Jason Allen Jones, as well as the elements of possession of methamphetamine with intent to deliver. The court bases the intent requirement or element on the fact of there being a large quantity of methamphetamine, 25 to 50 grams, well beyond what one would use for personal use. And also that the large quantity of methamphetamine was near unused smaller baggies, which is also indicative of an intent to sell narcotics. Do you agree well, and Mr. Rowe, what's the reason you believe a no contest plea as to count 1 is appropriate? Is it potential civil liability?
It is that, Your Honor.
Do you have any objection to a no contest plea as to count 1, Ms. Ambrositis?
No.
Very well, the court does find the reason given for a no contest plea as to count 1, minimization of potential civil liability, is an appropriate reason to accept a no contest plea, especially since the people have no objection thereto. Do you agree, Mr. Rowe, that there's a sufficient factual basis to accept the no contest plea to count 1?
I do, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Mr. Rowe, has the court complied with the court rule in the taking of the pleas?
It has, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Very well, in this case, the court has not agreed upon the possible pleas or the possible sentences with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the pleas are accurate and have been understandingly, knowingly, and voluntarily made. The pleas of guilty to counts 1, 2, and 3 are accepted and ordered entered on the records of the court. Bond is canceled and sentencing will occur at 10 a.m. on Monday, October 4, 2021. That will conclude the plea taking today, Mr. Jones, except that Agent Brubaker from the probate department might have some additional instructions to give to you. Agent Brubaker.
Thank you, Your Honor. Mr. Jones, I will be dropping off a packet of information for you to fill out. You need to fill it out completely, and an agent will be coming over to do an interview with you regarding that packet, okay?
Okay.
All right, thank you, Your Honor.
Thank you, ma'am. And thank you, Mr. Jones. Bond is canceled. The case is adjourned to the date and time indicated. We'll be in recess on that matter. Calling the case of People versus Paul Tremblay, file 21-6672-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Pardon me, Your Honor, Austin Arrow, appearing on behalf of Mr. Tremblay.
Mr. Tremblay, does Mr. Tremblay appear today? The record should indicate no response. The record should further indicate Mr. Tremblay was ordered to appear here today at 10:20 a.m. It's now a little more than 4 hours past that time. It's 2:45 p.m. By the court's clock, Mr. Tremblay still has failed to appear. He was ordered to appear here today to show cause why he should not be held in criminal contempt of court for allegedly failing to appear here in court. Previously, as ordered back in July 2021, do you know of any reason why the defendant failed to appear here today, Mr. Rowe?
I did not, Your Honor. My office sent a letter to him on July 28th to his last known address of 1907 Lakeshore Drive, Gladwin, Michigan, telling him of today's hearing and the time of the hearing. I have not heard from him, Your Honor, and I don't know why he's not appearing.
Very well, the court will cancel and revoke the defendant's bond and issue a bench warrant for his arrest. Bond on the bench warrant is set in the amount of $10,000 cash only, to be posted only in the defendant's own name. The record should reflect it's now 2:46 p.m. by the court's clock, and Mr. Tremblay, the defendant, still has failed to appear. Thank you, Mr. Rowe.
I believe this is Mr. Lane.
Calling the cases of People versus Timothy Lynn Lane, file 19-6106-FH and file 21-6558-FH. Would counsel identify for the record, please?
Your Honor, Austin R. Rowe making limited appearance from Mr. Lane for purposes of arraignment. Your Honor, I've had difficulty because of the jail having difficulty with its internet to talk to Mr. Lane. May I speak with him in the breakout room for a moment?
Sure.
Mr. Lane, I'll need you to unmute your microphone, please. Please unmute the microphone.
I didn't get a chance to talk to Mr. Lane, so we were brought right back in the courtroom.
Yes, I'm trying to get him to unmute his microphone so
Oh,
that you can hear
okay.
him.
All right, thank you.
There we go. Thanks, man.
Okay, Mr. Lane, I'm gonna place you in a breakout room with your attorney.
Okay,
Select join when it asks you.
okay.
Calling the case of Mary L. Roroff versus Huntington National Bank, file 20-900006-CH. Would counsel identify for the record, please?
Your Honor, Isaac Post for the plaintiff, Mary Roroff.
Good afternoon, Your Honor. Robert Kingo on behalf of the defendant, the Huntington National Bank.
Thank you, sir. Today is the date and time scheduled for a status conference in this matter. How did you want to proceed in that regard, Mr. Post?
Thank you, Your Honor. We actually, me and Mr. Kingo, through our clients, have come to a resolution. Part of that resolution is a stipulated order setting aside a sheriff's deed and dismissing the complaint with prejudice. This should, I believe, Mr. Kingo, you can correct me if I'm wrong, but I believe this should resolve this case completely. Mr. Kingo did prepare an order. I have the order with me. Mr. Kingo signed it electronically. I signed it with wet ink. And on the order, it says that Mr. Kingo drafted, and I agree with this, that this is a final order and resolves all claims. So we would ask, Your Honor, if you would execute this. We will probably want a certified copy for recording with the Register of Deeds. Is that true, Mr. Kingo?
Yes.
And we can get that later. I just am saying that more for the record, not necessarily asking you to do that at this moment. So if I may approach, Your Honor?
Sure. Any objection, Mr. Kingo?
No, I assume that's the same order I signed. I think it was last Friday. He signed it.
And you would like me to sign this proposed stipulated order setting aside the sheriff's deed and dismissing complaint with prejudice as well, Mr. Kingo?
Yes.
Very well. The court has received a proposed stipulated order consisting of 3 pages and bearing on the 3rd page the purported signature of Robert J. Kingo III. Also, bearing the signature of plaintiff's attorney Isaac J. Post. The court has reviewed that proposed order and has signed it, and will file it with the clerk of the court and ask her to provide true copies to both attorneys, and also a certified copy to plaintiff's attorney as well.
That'll work.
Thank you,
Mr. Kingo, they usually takes about 1 to 2 days for me to get that out. I'll scan and email it to you when I get it, so you can have at least a copy of it before the official one comes in your mail.
All right. Thank you very much. I appreciate it. And thank you, Your Honor, for your patience on this matter.
Well, thank you, Mr. Kingo, and I'm glad you reached a resolution. Thank you all for being here.
Thank you. Thank you.
We can handle this one while they're in.
Calling the case of People versus Patrice Renee Roux. File 12-4473-FH. Would counsel identify for the record, please?
Someone presided Spring on behalf of People.
Does anyone appear on behalf of Ms. Rue? The record should indicate no response. The record should also indicate this case originally was scheduled to be heard at 2 p.m. It's now 2:53 p.m. by the court's clock. Ms. Rue has failed to appear. Ms. Rue did file an application to set aside her conviction. I don't see any filing from the State Attorney General's office as to their position in this matter with regard to whether the defendant is eligible to have her conviction expunged. Do you have any preference as to how we proceed today, Ms. Ambrositis?
Your Honor, I do not have a filing from the AG's office either. And, you know, I learned of this case today when it was on the record. So the filings that were filed were a surprise to me because they never got to me to review, which I will take care of. I would ask the court to maybe reach out to the attorney of record on the application and reset this for a later date.
Thank you, ma'am. I will adjourn, well, I will adjourn the hearing without a date, and unless the applicant, Ms. Rue, refiles her motion or reschedules it, I'll consider dismissing it without prejudice. But for right now, I adjourn the hearing without date. Thank you, Ms. Ambrositis.
Thank you.
Thank you, ma'am.
Judge, I think that concludes my entire docket, so thank you.
Did we deal with the bond matter?
Yes, he was not available via his MDOC writ.
Okay, thank you, ma'am. Thank you, Ms. Ambrositis. The clerk confirms you are correct. At long last, we're done with the morning matters. Thank you, ma'am.
Thank you.
My staff for signature so far, please.
Okay, so you're done except for the 3:30 matter?
And Mr. Lane, who's in the breakout room with.
Oh, thank you very much. Absolutely. We'll be in recess.
All rise. Circuit Court's back in session. Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated. recalling the cases of People versus Timothy Lynn Lane, file 19-6106-FH and file 21-6558-FH. Would counsel identify for the record, please?
Your Honor, Austin R. Rowe making limited appearance for Mr. Lane for purposes of arraignment.
And appearing on behalf of the Clare County Circuit Court Probation Department and the Michigan Department of Corrections.
Agent Katie Brubeck, Your Honor.
Thank you, ma'am. Mr. Lane, would you raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Could you tell us your name, sir?
Timothy Lynn Lane.
Mr. Lane, you appear here today to show cause or to be arraigned on probation violation charges in file 19-6106-FH. You currently are on probation to this court in that file for the 10-year felony crime commonly known as possession of methamphetamine. As a consequence, if you plead guilty to violating your probation, or if you're found guilty of violating your probation, then the maximum penalty the court could impose would be 10 years in prison, and the minimum sentence would be discretionary with the court. Do you understand those things, sir?
Yes, sir.
In file 21-6558-FH, you also are on probation to this court in that file. And in that file, you also are on probation for the 10-year felony crime of possession of methamphetamine as well. Do you understand that?
Yes, sir.
As a consequence, if you plead guilty to violating your probation in that file, or if you are found guilty of violating your probation in that file, then the maximum penalty the court could impose in that file would be 10 years in prison, and the minimum sentence would be discretionary with the court. You understand those things, sir?
Yes, sir.
You do have a right to have a lawyer represent you in each one of these two files. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you. You understand those things?
Yes, sir.
Knowing everything that we've talked about so far, Mr. Lane, do you want to have a lawyer represent you?
Yes, yes, sir.
Do you have the money to hire a lawyer, sir?
No, sir. I can contact.
Okay. Would you like me to appoint a lawyer for you, sir?
Yes, yes, sir. I have a current contact.
Well, it's not really up to you who the lawyer that I appoint would be, but I will take into account you've expressed a preference for Ms. Tomczyk. For purposes of today, the court will appoint Attorney Austin Rowe to represent you at least through the arraignment.
Yes,
Mr.
sir.
Rowe, how does your client, Mr. Lane, want to proceed regarding being arraigned on these probation violation charges?
Your Honor, Mr. Lane pleads not guilty. He does ask for a court-appointed attorney, and I would note to the court that on Friday, in a case in the 80th District Court, Ms. Karen Tomczyk was appointed to be his attorney there. He waives the right to have a contested hearing within 10 days of arraignment without waiving the right to have a contested hearing, and he asks the court to amend bond.
Very well, then. First, the court will issue no not guilty pleas as to all probation violation charges in both files. Second, after today, the court will appoint Attorney Karen Tomczyk to represent the defendant in each file. Third, the court will schedule a status conference to occur on the morning of, at 10 a.m. on the morning of Tuesday, September 7, 2021, third or fourth. And with regard to bond, what is it your client is requesting, Mr. Rowe?
Your Honor, currently Mr. Lane's bond is set as $2,500 cash only in each file. Mr. Lane is asking the court to amend his bond to $100 cash only in each file. Mr. Lane has lived in Clare County for 8 years. He has aunts, uncles, father, and cousin who live in Clare County. He says he's never missed a hearing before. There's COVID-19 concern in the Clare County jail. And finally, he's presumed innocent until proven guilty by preponderance of the evidence. So for those reasons, he's asking the court to set his bond as $100 cash in each file.
That seems remarkably low, Mr. Rowe. It appears to the court that the bond is appropriately set. The motion to revoke or to reduce the bond is denied, and the cases are adjourned to the date and time indicated. Thank you, Mr. Rowe.
Thank you, Your Honor. I believe that concludes my cases before the court today.
Thank you, Mr. Rowe. We'll be in recess then.
All rise. Back in session, Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated. Calling the case of Robert J. Maxwell versus Ace American Insurance Company. Would counsel identify for the record, please?
Yes, this is Josh McFarland, appearing on behalf of plaintiff.
Does anyone else appear in this matter? The record should indicate no response. The record should further indicate this case was scheduled today for a hearing at 3:30 on the plaintiff's motion for entry of default judgment. It's now 3:34 p.m. by the court's clock. No one has appeared on behalf of the defendant. In addition, no one has filed any written answer to the plaintiff's motion for entry of default judgment. How would you like to proceed today, Mr. McFarland?
Your Honor, consistent with our motion, we would ask that you enter a judgment against the defendant. Unfortunately, we filed the complaint, filed the motion for default. We've received no response to either. As you can hear today, no one has appeared on behalf of the defendant to contest this either. So everything that we have sent, we've sent to the registered agent. We have green cards confirming their receipt. So at this point, I think the defendant has been given ample opportunity to respond to the complaint and has not done so.
Very well, the court will issue a default judgment against the defendant, Ace American Insurance Company. Will you be submitting a proposed order to that effect, Mr. McFarland?
Yes, we will.
Thank you. Record should reflect it's 3:35 p.m. by the court's clock, and no one has appeared on behalf of the defendant, which, considering it's an insurance company, is more than passing strange, but thank you. We'll be in recess.
All right.
Thank you, Judge.